Good afternoon. Today's hearing covers three items. The first I'll discuss is H.R. 467, the Halt Fentanyl Act. There isn't a day that passes where one doesn't hear of a tragic story of a life taken by fentanyl. There's no state, no district, or no community that has not been touched by this scourge. This public health crisis has stolen hundreds of thousands of futures, and it's only getting worse. Fentanyl overdoses are now the leading cause of death for Americans aged 18 to 45. In the last 2 years, the United States witnessed the largest drop in life expectancy since the early 1920s. Some of that is due to COVID, but a large part is due to drugs in general and fentanyl in particular. The majority of this deadly substance is seeping in from our open southern border. Drug cartels are gleefully taking advantage of the Biden administration's failure to secure the border and pushing this dangerous and deadly substance onto our streets. This must end. The Halt Fentanyl Act takes two concrete steps to help end this crisis. It permanently lists all fentanyl-related substances on Schedule 1 of the Controlled Substances Act, and it creates a registration process for research into fentanyl-related compounds. These common sense and necessary changes ensure continued research into those substances and gives American law enforcement the tools they need to stop fentanyl-related substances from entering the United States. Our second item is a joint resolution of disapproval covering a proposed Biden administration rule concerning emissions from newly manufactured heavy-duty trucks and engines. Senate Joint Resolution 11, which passed the Senate with bipartisan support, overturns a rule that will drastically increase the cost of new trucks and new truck engines for little environmental gain. The Biden administration's rule will make it harder for carriers to purchase new, lower-emitting trucks and engines, particularly for the small carriers with fewer than 10 trucks that make up over 95% of the trucking industry. These costs will ultimately be passed on to consumers, raising the prices for nearly every good at a time when American families and businesses are already suffering under rampant inflation thanks to President Biden and congressional Democrats' out-of-control spending. I know my friends in the future will insist that this rule is essential to reducing pollution. While it might tick the box for their radical Green New Deal agenda, it will likely have the opposite effect in practice. The EPA estimates the technology required to meet the new administration's rule standard could cost more than $8,000 per vehicle. Many small operators will be unable to shoulder such a dramatic price increase and will instead continue using older, higher-emitting trucks for longer periods of time. In supporting S.J. Res. 11, we are standing with the American truckers, protecting our nation's supply chain and safeguarding families from even higher costs. Finally, our third item is House Joint Resolution 45, which disapproves of President Biden's student loan forgiveness scheme. Last year, President Biden announced his plan to unilaterally forgive up to $10,000 in federal student loan debt per borrower. The Congressional Budget Office estimates that this plan may cost as much as $400 billion. It transfers the cost of these loans from the borrower to taxpayers, some of whom may not have attended college, didn't have the opportunity to attend college, or have paid off their student debt. And to make matters worse, this spending has not been authorized or appropriated by Congress, meaning that this plan is likely unconstitutional. In fact, back in 2021, former Speaker Pelosi agreed, saying that, quote, people think that the President of the United States has the power of debt forgiveness. He does not, unquote. The Supreme Court is expected to weigh on this matter this summer. Today's joint resolution disapproves of President Biden's potentially unconstitutional scheme. It will ensure that taxpayers are not forced to spend billions paying off someone else's debts and takes a firm stand against the president's attempt to overlook the Constitution and Congress. I now turn to the gentlelady from Pennsylvania for any remarks she cares to make.
Thank you, Mr. Chairman. Yes, we are here today to consider three different measures. Americans know all too well the devastating impact fentanyl has had on communities and families across the country. And we would welcome the opportunity to discuss real evidence-based solutions to this real-time tragedy impacting all of us. But H.R. 467, the Halt Fentanyl Act, does not provide that opportunity to comprehensively address this public health crisis. Instead, the bill doubles down on the well-established failures of the war on drugs with an incarceration-first approach to a public health crisis. We know that mandatory minimums don't work. When Congress imposed mandatory minimums in response to drug abuse in the 90s, we saw prison populations soar and communities devastated without appreciable impact on the availability or use of these illicit drugs. Over the past decade, we saw policymakers from across the political spectrum, from the Koch brothers to the Obama administration, come to the realization that these kinds of mandatory minimums do more harm than good. And we saw efforts to roll back those mandatory minimums, reduce incarceration, and repair some of the harm that had been inflicted with laws such as the First Step Act, gathering bipartisan support. But the bill we see today resorts to the same failed playbook of mandatory minimums, tying the hands of judges and exacerbating racial disparities in our criminal justice system. In addition to the bipartisan proposals of our colleagues, there are bipartisan solutions available. They are out there. There's a bipartisan opioid task force. And in addition to those bipartisan proposals, the Biden administration has also proposed comprehensive fentanyl legislation to permanently schedule fentanyl-related substances without pulling from the failed war on drugs of the past. Unlike the Biden administration's proposal, H.R. 467 takes a never-before-employed approach to scheduling fentanyl that limits the ability to remove or reschedule fentanyl-like substances if scientists find that the drug has medicinal or therapeutic value in specific cases. We can all agree that Congress needs to act to keep fentanyl off our streets. But a successful plan has to tackle the root causes of substance abuse. We can't incarcerate our way out of this crisis. It's a public health problem, and we have to approach it as such. So there are bipartisan solutions on the table, although not being brought to the floor. Unfortunately, the extremists controlling the House agenda these days aren't willing to work collaboratively to address the underlying social and health factors that cause our nation's substance abuse crisis. One of these bills is the Stop Fentanyl Overdoses Act, which, as I mentioned, has been put together by the bipartisan Opioid and Addiction Task Force. This act, among other things, expands access to overdose reversal medications, establishes a program to offer medication treatment for opioid use disorder to individuals who are incarcerated. It expands testing for fentanyl and related substances, increases information shared by public health departments and law enforcement, and streamlines the regulatory structure. Congress has voted 8 times now to extend the temporary class-wide FRS scheduling that is at issue in the bill before us today since it was implemented by the Trump administration. Yet, the latest data from the Centers for Disease Control and Prevention shows an estimated 107,477 overdose deaths between August 2021 and August 2022. We need to do more than simply schedule FRS and incarcerate people if we're truly going to tackle this issue. In addition, the debt limit plan that the House majority pushed through a couple weeks ago cuts Customs and Border Protection funding, handicapping that department's efforts to seize fentanyl as it crosses our borders. The prediction is it will allow an additional 350,000 grams of fentanyl across the border due to decreased enforcement. Just 1 week ago, the House majority passed policies that make it easier for smugglers to bring fentanyl into the country. Now they bring up a talking point bill so they can say they're trying to stop the crisis. But that's the pattern emerging here. House majority complains about a problem, passes a bill that makes the problem worse, then tries to cover it up by passing another bill with a flashy title that does nothing to fix the underlying problem. We're ready with real solutions, but we need the Republican majority to come to the table to solve this and so many other crises. So in addition to H.R. 467, we're considering 2 Congressional Review Act disapproval resolutions. H.J. Res. 45 would reverse the Biden administration's action to ease federal student debt. In Pennsylvania, student debt has reached epic proportions in terms of a crisis. We have more people with more debt than almost every other state in the country. Ending the payment pause would be disastrous for student borrowers. If successful, tens of millions of Americans will be pushed abruptly into unplanned repayment, adding thousands of dollars in payments and interest back on their loans. There would be a wave of defaults that would only exacerbate our current student debt crisis. This resolution would create more chaos and confusion as the courts are working to make a ruling on this process. So Congress still needs to take substantive action to support borrowers and make college more affordable. This bill doesn't do that. Since Congress didn't act, the president did, and now this extremist majority is trying to claw back the support that has been provided for student borrowers. It's not the right way to go about this, and it is not helpful. It does nothing to solve the underlying issues. Finally, SJ Res 11 would reverse a well-researched and vetted rule encouraging decreased emissions in the trucking industry. Why is Congress once again using CRAs to make it easier for polluters to pollute? Especially when we know these kinds of truck emissions have a direct negative impact on respiratory health. In my district, 1 in 4 kids suffers from childhood asthma. We've seen data with respect to this regulation indicating that if you live within 200 yards of a highway that has heavy truck traffic, it's going to impact your health. I-95 runs right through my district. We have houses that aren't 200 yards from one of these, from the highway. They're about 50 feet. So it has a real direct negative impact. And once again, using a CRA to rescind a rule without having any policy or process to replace it simply is irresponsible. So we see the House majority pushing half-truths and messaging bills rather than coming to the table to actually provide solutions to the problems that face our American communities. They would rather undermine, repeal, and roll back democratic policies than offer substantive alternatives. It's a squandered opportunity, it's irresponsible, and it doesn't serve the American people. I look forward to hearing from our witnesses, and with that, Mr. Chairman, I yield back.
Thank you. I'll just note for the record, the Republican majority has not introduced legislation that would cut funding at the border. Quite the opposite. The Appropriations Committee is currently considering a Republican proposal to substantially increase money for border security. Without objection, any prepared statements that our witnesses may have will be included in the record. I'd like to welcome our first panel, Representative Morgan Griffith, Representative Bill Johnson, and Ranking Member Frank Pallone from the Committee on Energy and Commerce. Mr. Griffith, welcome back to the Rules Committee, and I welcome your testimony.
Thank you, Mr. Chairman. I appreciate you doing this today. And as you said in your opening comments, it's unfortunate, but most members on this committee know someone who's been affected by the drug overdose problem and epidemic plaguing our country. According to the Centers for Disease Control and Prevention in 2022, there were more than 107,000 overdose deaths that occurred in the United States. 67% of those deaths involved a synthetic opioid like fentanyl. These record numbers are due in large part to increasing presence of fentanyl and, in some cases, fentanyl analogs, which are approximately 100 times more potent than morphine and 50 times more potent than heroin. The lethal dose of fentanyl is just 2 milligrams, or about 4 grains of sand. A loophole cartels used prior to the temporary listing of analogs to traffic fentanyl into our country was to create fentanyl analogs. The cartels did this in an attempt to evade our criminal laws. Right now, fentanyl analogs are considered Schedule I substances, but only because of a series of temporary scheduling orders which expire on December 31st of 2024. Since then, since we've started these temporary rolling scheduling, we have seen a reduction in trafficking of the fentanyl analogs into our country. What basically happens is that the cartels, recognizing that the punishment is just as severe for bringing in the fentanyl analog as it might be for the fentanyl, they don't bother to try to figure out ways to get around our laws. But before we had these laws, Mr. Chairman, what would happen is they would scheme up a way, whether they be in China or in Mexico, to change the chemical formula ever so slightly, so that they could claim in court, as they did so in a in several cases, but in one specific case, tried to claim that it wasn't covered by the statute. And so that's why we need this bill, to make sure that it's permanently out there and dissuade the criminal cartels and the drug pushers from trying to figure a way around the law, because we want to block that loophole that existed at one time and could exist again. So since we started that, we have seen a reduction in the trafficking of the fentanyl analogs into our country. This bill aims to curb overdose deaths by permanently scheduling fentanyl analogs as Schedule I substances. This will strengthen law enforcement's ability to prosecute fentanyl traffickers and act as a deterrent. The Halt Fentanyl Act also promotes research, and this is something you don't get in the temporary order. It promotes research into the various analogs by removing barriers to that research. In the Energy and Commerce Committee, we have heard that there are as many as 4,800 different potential analogs for fentanyl. Our experts at the NIH, FDA, and other agencies have studied roughly 30 of those 4,800 analogs. By encouraging research of Schedule I substances like the fentanyl analogs, we can better understand how these substances work and how we can prevent potentially harmful impacts in the future, and we may actually find something that's positive. We don't expect to, but we might. Because fentanyl has a proven medical use, it is considered a Schedule II. So fentanyl itself is a Schedule II narcotic. But illicit derivations or derivatives of fentanyl, also called fentanyl analogs, currently have not demonstrated medical value. Let me be clear, this bill will have no impact whatsoever on a physician's ability to administer fentanyl in proper medical scenarios. HALT deals specifically with the analogs, not fentanyl itself. DEA has said that permanently scheduling fentanyl analogs is their top legislative priority, and that's in this administration. We must address this bipartisan issue immediately and not allow this temporary extension to expire. Just today, and this is why I say it's bipartisan, just today, the Biden administration released a statement regarding the bill we are discussing. In that statement, they supported the two provisions that I've just described, permanent scheduling and streamlined research. So, previous to today, the Biden administration also had recommended a few other items they would like to see for fentanyl analogs. I'm open and willing to have those discussions, but that is not this bill. We should vote to advance this bill where we have commonality with the White House and it makes common sense. Now, I'm going to tell you that this bill, once we've passed this bill, we can continue to work on other issues. But let me address a couple of the issues, Mr. Chairman, that have been raised. We've dealt with the fact that some folks tried to scare people into thinking you couldn't use fentanyl for medical purposes. That's not the case. Further, it's correct that this bill does not solve all of the fentanyl issues out there or all of the drug issues out there. If it were to solve that, I would say fabulous. But it's very difficult to come up with a single bill that would solve all of our problems. And I would submit to find that perfect bill, you would be like those who chase the end of the rainbow looking for that pot of gold. It's not likely to happen in one fell swoop. What we need to do is to have building blocks. This is a building block. That research component in particular moves us forward on trying to figure out how we can try to solve our opioid problem and our fentanyl problem. And I think that's important. Now let's talk about mandatory minimums. This bill does not do anything on mandatory minimums. What it does is that it adds fentanyl analogs to that Schedule I for all the reasons I previously stated. If it were to deal with, if we want to have a discussion, Mr. Chairman, on mandatory minimums, I'm open to that, but Energy and Commerce is not the committee that comes out of. That's Judiciary. This bill is an Energy and Commerce bill because it deals with the analogs and the science involved. This is not the bill for dealing with mandatory minimums. It's a debate we as a society ought to have. It's a debate that at some point this Congress ought to have. But a overall, overarching mandatory minimum discussion needs to take place in the Judiciary Committee. It needs to be well thought out, and it needs to be studied in depth. And I know that my colleagues on the other side of the aisle, while they may agree with the principles of this bill, they want to tackle that one too. Perhaps they could have done that in the last Congress. It is a serious issue, though. I do not want to underscore that it is not, but we used to have a saying in the Virginia legislature when I was there, and it was that, if this bill, gets close but it's not quite what you want, and it wouldn't be germane to add something like mandatory minimums to it, we used to say to each other, well, get your own bill. We'd be happy to look at it, but get your own bill. This bill does what I said. It's a building block. It helps us move forward. It permanently schedules fentanyl analogs, and it creates what I consider to be a very valuable component in that it allows us to get the research done to see if there's something out there in the other analogs that might be helpful going down the road. And that's an important step as well. So I think it's a great bill, and I would hope that this committee would forward it to the floor in its current form. And
Thank you very much for your testimony. Chair will now turn to Representative Johnson for his testimony on Senate Joint Resolution 11.
Well, thank you, Mr. Chairman. I appreciate the opportunity to speak in support of SJ Res 11, a joint resolution providing for congressional disapproval of the EPA's regulation relating to, quote, control of air pollution from new motor vehicles, heavy-duty engines, and vehicle standards. The resolution, which I urge you to let the House consider under Chapter 8 of Title 5 United States Code, rescinds the EPA's detrimental rulemaking that would impose overreaching technology-forcing standards on heavy-duty trucks. This EPA rule is another step in the Biden administration's rush to electrify the transportation industry at the expense of our economy and the American consumers. The rule covers heavy-duty vehicles ranging in size from Class 2B trucks, such as the Ford F-250, to Class 8 trucks, known as semi-trucks. These trucks transport everything from food to consumer goods that directly impact the affordability and quality of life of the American people. SJ Res 11 rightly revokes EPA's heavy-duty trucks rule, which would negatively impact the trucking industry in a variety of ways, and in doing so, would also come to the rescue of Americans dependent on critical deliveries by the trucking industry. Now, EPA acknowledges that these new engine and vehicle standards are 80% more stringent than the previous standards. These unnecessarily stringent standards ignore the fact that new trucks have already reduced nitrogen oxide emissions, or NOx, by more than 98% over the last 35 years. Furthermore, the time frame by which heavy-duty trucks must meet the new engine and vehicle standards is unworkable. The EPA rule goes into effect for model year 2027, giving truckers extremely limited time to achieve compliance. Next, the EPA itself has admitted that the new rule would dramatically raise costs for trucks. Overall, the EPA's own projections indicate the cost of the new standards will be $39 to $55 billion. On a per-truck basis, the agency estimates that the emissions reduction technology to meet the new standards would cost more than $2,500 per Ford F-250. EPA also projects that new engine and vehicle standards will cost $8,304 per semi-truck. Even worse, the American truck dealers estimate that the cost per truck will be closer to $42,000. Smaller trucking companies that cannot afford these truck restrictions, especially at today's higher interest rates, will be forced out of business, which will have a direct impact on supply chains and the transportation of goods. If truck owners or operators manage to stay afloat, we all know that it's the American consumers that will ultimately be forced to bear the cost of this regulation. As the cost of shipping goods by truck increases, the prices for all such goods transported by truck will rise. Given that Americans are already struggling due to high inflation, EPA regulations that deliberately increase prices would be disastrous. Finally, the new heavy-duty truck regulations will not achieve the emissions reduction benefits that the EPA claims. In fact, it could do the exact opposite. The Owner-Operator Independent Drivers Association warns that small business truckers will likely stay with older, less efficient trucks by this rule standard if they cannot afford the new trucks with compliant technology. The biggest source of NOx emissions are older trucks. So keeping the used, higher-emitting trucks in service for a longer period of time will actually increase emissions rather than decrease them. So it's our responsibility to protect Americans from bearing the cost of the Biden administration's ineffective and disastrous so-called Clean Trucks plan. Regulatory stringency for stringency's sake is no virtue. EPA's heavy-duty truck rule would only increase prices for American consumers and destroy already fragile supply chains for critical goods. Just a few weeks ago, the Senate, led by Senator Fisher, voted in a bipartisan manner to disapprove of the EPA's rulemaking. It is time for the House to take similar action and vote to stop President Biden's unjustified and impossible rush to electrify heavy-duty trucks. I encourage my colleagues to support SJ Res 11. And Mr. Chairman, I yield back.
Thank you for your testimony. The chair now recognizes our good friend, the ranking member of the Committee on Energy and Commerce, Mr. Pallone, for his testimony on the legislation before us.
Thank you, Chairman Cole. And I have two statements, one on the fentanyl and one on the clean trucks that I'll submit for the record, and I'll try to summarize if ask unanimous consent to do that, if you will. Let me just say, I listened to Mr. Griffith, and I have to say that he did, in a very rational way, I think, explain what's going on here. Even though I still disagree with him, I think he kind of laid out what the issue is. And what I would say is that, and what I really want to make the point here is that, and I suppose that's the advantage of being on the Rules Committee, that even though this particular bill comes from Energy and Commerce, you have the ability, of course, to add things through amendments or whatever that are not necessarily related to what comes out of our jurisdiction. And the reason I say that is because it's true that Democrats agree that there should be a permanent extension of the existing class-wide scheduling for fentanyl-related substances, FRS, and it's true that we do support more research, which this bill does. But the problem is it's not accurate to say, and I don't know that you said that, but it's not accurate to say that the Biden administration supports this. Obviously, the president has issued a veto message saying he would veto it. And what the president came up with was a proposal that I think would have been a true compromise and could have led to both sides, both Democrats and Republicans, coming here today in support of this bill. And I'll tell you what's lacking, what's not in that, what the president proposed. But I would mention to you that there's an amendment by Mr. Pappas and also based on a bill, exactly like a bill that Mr. Pappas and several Republican members sponsored. It's your amendment number 4, I would mention, which is a substitute, essentially. That would incorporate what the president's interagency proposal does. So I would urge you to take a look. Obviously, you'll look at that amendment number 4, which is bipartisan, and if you adopted that, I think we would have a good compromise. Basically, what I would reiterate is that this is just continues the status quo. In other words, the status quo right now says that fentanyl-related substances are under Schedule 1, and that, of course, triggers things like mandatory sentences and doesn't have any kind of off-ramp where an analog, if we find that it's actually helpful in some way, could be taken off and could not be included in Schedule 1. And I think I want you to understand that I don't think anything in this bill, because it just continues the status quo, is going to stop the problem of fentanyl coming into the United States, of overdoses, of deaths. I mean, there's nothing in here that provides for treatment or more money for enforcement or anything of that nature. It just continues the status quo. And the status quo, in my opinion, is failing. I think we would all agree that it's failing. I mean, the fact of the matter is, just to give you an example, though, even though these analogs have been continuously scheduled since 2018, overdoses have not gone down, nor have we made a dent in the incidence of opioid use disorders. And in fact, we've actually found that there's something like 4,800 different fentanyl-related substances, and as of this moment, DEA has only encountered about 37 different types, and they've already found some that have medical uses and that actually would be helpful. So one of the things, so what basically the Biden administration proposal does, and the amendment number 4 does, it not only recommends a permanent extension, which we discussed, it not only expedites research for all Schedule I substances, which we discussed with Mr. Griffith, but it creates an off-ramp to ensure that substances that are deemed to be not harmful or have potential medical applications are not improperly classified under Schedule I, and we know there's some that are in that category. It reforms the mandatory minimum standards involving these analogs that says that there is no mandatory minimum sentence unless an offense results in serious bodily injury or death. And again, for those of us who feel that, you know, it should be up to the judge, unless it is a serious offense, to decide, rather than have mandatory minimums, which, as you know, have been very discriminatory, oftentimes discriminatory, particularly against minority groups, low-income people. And then the other thing that the Pappas Amendment does, and that the President's interagency proposal says, it enables individuals convicted of an offense involving an FRS that is subsequently removed or rescheduled to seek reduced or vacated sentences. So all we're really saying, all the Democrats are really saying to all of you is that to just continue the status quo doesn't accomplish anything. We have some proposals out here in addition to what Mr. Griffith mentioned with regard to the research that we believe would make more sense rather than just continuing with the status quo, which ultimately I don't believe is going to accomplish anything. I mean, these are the kinds of guardrails. And I would point out again, before I move to the clean trucks, that this bill does not provide any resources for prevention, treatment, recovery, or harm reduction, nor does it provide law enforcement or public health agencies with any additional resource to detect or intercept illicit drugs at ports of entry or wherever. The fact of the matter is that the bill in its current form, I don't think would really accomplish anything. And so that's why I oppose it and ask you to look at this alternative. Now, let me talk briefly about the clean trucks. It's kind of funny to move from one of these to the other because they're not really related at all, but that's okay. So in terms of the SJ Res 11, the heavy-duty CRA, I just want to stress how important this rule is and why I think that it's a huge mistake to use the CRA process. As you know, the CRA process precludes any further regulation in this space. And I have to say, I mean, I heard Mr. Johns talk about costs, but the fact of the matter is EPA has an obligation to protect the public health. And no, when you pass the CRA, you're not providing any alternative at all. You're actually saying that we can't regulate in this space in the near future. And I have to stress that the industry doesn't even oppose this bill. So why are we using the CRA as a method of dealing with this? If you want to have an alternative, then put forth one, but don't use this CRA process. I mean, I only mention it because, again, I know this came over from the Senate, so if this passed, it would go to the president. But keep in mind that the only reason this passed the Senate was because one of the Democratic members was absent, and of course, Mr. Manchin voted for it, so I guess it got 49 to 48 or something like that. I mean, this is not like there's not like a huge outpouring of support for this thing. And I think the reason is because it's very important to have a rule or regulation that deals with this problem and not just say we're not going to regulate in this space. So just briefly, and again, I'm not going to go through all of it, but just to give you an idea, we haven't updated the heavy-duty emission standards for nitrogen oxide for more than 20 years, right? And this standard says, I mean, here, I just want to give you, I won't prolong this, but I just wanted to tell you what the rule would do. The rule, EPA estimates the rule will result in $200 billion in health-related benefits, right? Beyond, in other words, it will save money through the health benefits that it provides. The rule is expected to prevent up to 2,900 premature deaths, 6,700 hospital admissions and ER visits, 18,000 cases of childhood asthma, 1.1 million lost school days for children. Now, all these benefits just get thrown away, and we can't regulate anymore in this space. Also, I want to note that during the rulemaking process, EPA engaged extensively with communities, with tribes, with state and local governments. It engaged the industry. Industry is not opposed to this, and that's why they're supportive, because there was so much activity involved with them in putting this together. So I don't want to prolong it. My statement has more information about the benefits of this. But I just think it's unfortunate that the majority feels that they should get rid of this rule, which is so beneficial, supported by industry, and they don't have an alternative at this point. So with that, I'll yield back, Mr. Chairman.
Thank the gentleman for his testimony. Chair has no questions at this time, so I'll turn to my good friend, distinguished Vice Chairman of the committee, Dr. Burgess, for any questions he may have.
Thank you, Mr. Chairman. And Chair Griffith, let me just ask you if you could clarify, because we kind of heard conflicting information. The current temporary scheduling of fentanyl-related substances, has it saved lives during the time it's been in effect?
We believe that it has, and the reason that we believe that is that it stopped the cartels from trying to figure out ways around. Now, does that stop fentanyl? Does that stop other opioids? No, it does not. But it does stop deaths by the analogs. That has occurred, and it makes it easier on law enforcement to both intercept without having folks be chemistry majors or master's degrees on the front lines of our law enforcement. It makes it a whole lot easier to test, and if it turns out that there is an analog, we don't have to worry about it being thrown out of court because they've somehow found the way around the law. So it helps the frontline law enforcement. That's why DEA said this was one of the most important things in one of our hearings that we held this year, one of the most important pieces of legislation that they could get to help them. And we believe that the research component, should there be found anything that is efficacious in medical terms, and so far there's only one that has any sign that, at least the testimony in front of the committee has only said there was one of the ones that have been tested that might have some benefit, but we're way too early. But that's why we put the research component in there, so that we could find out and then deschedule it appropriately if it did have medical benefit.
And the research component is important. I don't think it was this Congress. I think it was the previous Congress. And again, I don't unfortunately remember the name of the individual or the agency that they represented, but they speculated that there could be one of these analogs that's safer than water, and you wouldn't want to prevent that from coming forward. Pretty big stretch, but nevertheless, you actually provide a pathway. If there is one of these that is safer than water and has additional benefits, there is the research path to elucidate that.
There is, and if I could clear up another issue that I understand it gets confusing and things happen. My colleague and friend indicated that there'd been some kind of a veto message. There's not been. In fact, and it's one of those things, I'm happy to give it to you all if you want it, but it came out today. I was a little surprised as well. You have a copy of it. That the White House actually came out. They didn't say vote for HR 647, but on HR 467, they said the administration calls on Congress to pass all of these critical measures to improve public safety and save lives, after fully describing the bill. And they referenced that in their numbers.
Right, but the gentleman yielded. I'm sorry if I gave that impression.
Yeah.
I mean, basically the way I read this, and you can read it or give it to you if you want, is saying what I said, which is that they agree with the two components.
That's correct.
Permanent scheduling and research, but they would like the legislation to include the additional provisions that were in the president's proposal, which I mentioned.
And I think that's accurate. They would like that, but they also encourage that we get these two done. And I'm open to discussing further measures as we move forward. That's why I call this a building block. It is not meant to be something that is, the be-all to end-all. But the research is, to me, and as you know, Dr. Burgess, this is something I've talked about in Energy and Commerce a lot. Getting the research done on these substances that appear to be dangerous, but making sure we have all the research has always been important to me on both this substance and others, which is why, in order to introduce this bill, I wanted to make sure it had that research component. We don't really have that capability now. Our universities are a little nervous with the temporary scheduling. They're nervous about getting involved in doing any research. This clears the path, makes it clear what they can do and what they can't do, how you register to do the research. I think that's a very important component of this bill, because it will allow us, if there's something that it works out to be a positive from a medical standpoint, we're not just putting a stiff arm on it. We're telling our universities, go research it, see if you find something. And if you do, fine, we'll reschedule quickly. If not, then we won't. And right now, we're in that, they haven't found anything yet. But there's really not been enough research done to say that out of the 4,800 analogs, that there's nothing out there. But thus far, there hasn't been anything that has been earth-shattering or something that we really need to help people medically.
So it seems as if there's a difference of opinion as to whether or not the president would veto this. It strikes me that the judicious way to approach that will be to pass Mr. Griffith's bill, send it to the president, and see if he vetoes it. I mean, that will answer the question, won't it, Mr. Pallone?
Yeah, but the point I'm trying to make, Dr. Burgess, is that this bill isn't going to do anything different than what we already have, right? Okay, other than the research. But the point with the
That's a, if I may,
Yes,
that's
but
a pretty big
understand
step.
But understand one thing, and that is, you talked about an off-ramp. In other words, yes, if you do the research and find out that some of these drugs actually have a beneficial use, which we believe there is evidence of that, the bill doesn't provide for that off-ramp. I mean, all I'm saying to you is that there's three things that are not included and that the president is mentioning. One is that there should be some off-ramp, so if the research shows that, in fact, if some of these drugs shouldn't be scheduled,
I think it's there.
then they can be taken off. That's not allowed under the bill. And you know how hard it is to go back and make a change. And then the second thing is that we not have mandatory penalties unless the offense is serious, based on life or limb. And then the third thing, I believe, is that the president recommended, I think I mentioned it, was was this idea that individuals convicted of an offense involving these analogs that subsequently removed or rescheduled can seek a reduced or vacated sentences. So I guess what I'm trying to say is, why not, rather than just pass a bill that makes this permanent when it's already, in fact, the law, why not use this opportunity to do some of these other things that I think will make a difference? Because right now, there's no reason to believe that this bill is going to make a difference.
Yeah. I would just ask the question why you didn't do that in the last Congress when you obviously had an opportunity to. Yes, Mr. Griffith.
Well, and if I might say, I believe the off-ramp is there. When you take the language in the bill combined with current law, I think that creates a coupling and that there is an off-ramp. And all the other items that my good friend just indicated, that the White House and the Democrats would want, they're all part of the Judiciary Committee's jurisdiction. And we're trying to get something passed that will have a positive impact, and that research component is very positive. The permanent scheduling is positive in the sense that we don't have to come back every 2 years and do it again. But the research component, I think, is extremely positive. But if we had to send this back and go through the hoops of the Judiciary Committee, it would take us years perhaps to get anything done. Let's get what we can get done and have that discussion another day, because as I have said many times, I do believe that it is proper for us as a body to have a debate on mandatory minimums and take a look at it, and the whole business about if it's descheduled, if a particular analog is descheduled, taking a look at any convictions that may have occurred under that. I think that's a proper discussion, but it has to start in the Judiciary Committee, not in Energy and Commerce, and it can't be added to this bill properly. Even though Rules has great leeway in many things, we clipped that a little bit with our new rule on germaneness. So I believe that any of those amendments would not be germane, and if allowed on the floor, would be subject to a challenge under the new rule. So I recognize the desire and the past practice that you all might have been able to do that, but let's get this little simple bill. I don't disagree with my colleague. It's not a giant bill, but sometimes you can do really good work with a series of little bills.
Yep. And, I mean, the fact is, we're talking about, what, 104, 107,000 deaths per year? I mean, there is a degree of urgency here, and it does rise to the level of let's fix what we can. And if we can come back and fix other stuff later, we should do that. I know you've worked on this a long time, and I really appreciate the work product that you've turned in, and I think the rule ought to reflect that and bring it to the floor in a timely manner. And if the president wants to veto that, then he's free to do so. But I think it would be an enormous mistake, given the amount of suffering that this compound has caused, coupled with the fact that we have a porous southern border that is just allowing this stuff to pour in. Chairman Johnson, let me just ask you a question, if I could. we're kind of in an unusual position here that the Senate's already acted, and now we're being called upon to act. So that's a new phenomenon for most people, but it's a significant opportunity for the House now to rubber stamp what the Senate has done and send that down to the president to see how he feels about it.
Well, it is, and you know, there's my colleague, Ranking Member Pallone, said that didn't see a lot of overwhelming outside support, but that's different than the information that I have. The American Trucking Association, the Owner-Operator Independent Drivers Association, the Transportation Intermediaries Association, the National Tank Truck Carriers, the Truckload Carriers Association, the National Federation of Independent Business have come out in support of this, and I guarantee you that the American consumer will come out in support when they find out that this rule, if it goes into effect, is going to require the cost of everything that's transported by truck to go up even higher, driving inflation even higher than it is today.
Sure. And our truckers were unsung heroes during the pandemic. They were the ones that worked every day to make sure that getting through that tough time, we had what we needed to do so. And so I appreciate very much you, unfortunately, the Senate acted first and took away from you the pleasure of moving first with this, but I think we ought to support the Senate in their efforts. Thank you, Mr. Chairman. I'll yield back.
Thank you very much. Gentlelady from Pennsylvania is recognized for whatever questions she cares to pose to our witnesses.
Thank you. And I would just note that the 467, HR 467 was in fact referred to Judiciary, but Judiciary did not consider it and mark it up. So it is going to the floor without having had that really critical debate. And it just feels like an upending of legislative process to say, oh, here we're just going to pass this thing, even though it's going to have this serious negative impact on a lot of people, so that we can maybe address another problem. Maybe we should just strip that provision out of it. One thing I did want to ask our Republican colleague, we know that the Fourth Amendment that we have here is the SAFE Act, which was introduced with bipartisan support and does address many of the comprehensive issues that we need to address, in addition to what you've termed the building blocks in the bill before us. Would you have any objection to that amendment getting a vote, a fair debate and vote, in order to address some of the additional issues that are so crucial to really drive down fentanyl use and abuse?
I appreciate the question. So here's one of the problems I think we have in Congress. We create these gigantic bills, and you are fortunate enough not to be in our conference where I talk about this stuff on a fairly regular basis. But we have these gigantic bills, and then what happens is people are forced to vote for something because they're afraid of what it might do or look like back home, because the bill has, you know, pages and pages and pages, and yet it boils down to a soundbite that's 10 seconds, and there's a whole lot more in there. So I have, since I got to Congress, been working to try to get us to get to smaller bills, and I believe that amendment is not germane to the bill that I introduced and is not properly before the House. And particularly, I was one of the folks who pushed and crafted the current germaneness rule, which would allow a challenge on the floor. Should we put that amendment on there? I think it's challengeable and would be defeated on the floor for being not germane. And so I cannot in good conscience agree to something that I don't think is germane and is contrary to the long-term good work of Congress, because what we need to do is we need to be taking smaller bites where people can say, okay, I'm for this, instead of trying to say all the time, we got to have a giant bill that solves all the problems. Because if we would take the smaller bites, I believe over the course of a decade, we would get more work done for the American people in Congress than to try to pile everything into a single bill. So while I may agree with principles or some of the things that are in that amendment, I cannot agree to the amendment being added to this good bill that does two simple things, that's clear for the American people to understand, and is moving the ball forward. And like I said, it's one of my favorite adages that came out of my days in the Virginia legislature. Happy for you to get your own bill, might support it, but it's not appropriate on this bill.
Okay, I've been advised by staff that in fact does meet the germaneness rules in the House rules, regardless of whether or
Okay,
not
here's
you
the
would seek
problem,
to challenge it.
But here's the
But
problem.
it is germane.
No, it's not.
Well.
And here's the problem, and people don't understand it. We have not tested this new rule yet. The idea is to make it stricter. It does not matter what the parliamentarians say at this point. I understand that drives a lot of people crazy on both sides of the aisle. But I crafted this rule so that we could redefine germaneness and come up with a new rule. And under this new rule, I believe that it is not germane, but it has not yet been tested.
Sounds like that's something else that would get tested, because I'm hearing adamantly in my ear that the germaneness rule itself is not new. But I do think we do agree on one thing, which is that it is very possible for bills to have too much in them. And I think what's too much in this one is the mandatory minimums.
And that's not in this bill, that's current law.
Okay. But to the extent that it would increase the use of mandatory minimums in this situation. Mr. Pallone, could you tell us a little bit about the problem with the scheduling here and why it makes it more difficult for research to go forward?
Well, first of all, let me explain that, because I don't think I did, that right now, the scheduling of these analogs under Schedule 1, we've passed legislation that allows that to continue until December of 2024, right? So I just don't want to give the impression that you're really doing anything today that has any immediate consequence, right? We have no evidence that this scheduling is going to lead to less overdoses or less, fentanyl analog coming in at the border. I mean, that's the current law. I mean, Mr. Griffith agrees with that. And that's the case at least until December of 2024, right? Which is, another 18 months from now, right? So whether the Judiciary Committee has decided to deal with it or whether or not it's germane, I agree with you. This is germane. This amendment could be adopted today. It's a bipartisan amendment, and it would definitely, deal with your problem and mine, which is that we're just putting all these things under mandatory minimum sentences. We have no off-ramp. We have no way for somebody who's to be convicted later to be taken, to reduce their sentence. And but there's no reason to do this, because we've got plenty of time to even, whether you want to do it as an amendment today or you want a Judiciary Committee to proceed, you have plenty of time to do it. You're not accomplishing anything today. But your question was, again, about the research. Yeah, in other words, what he's saying, and I think what Dr. Burgess is saying, is let's proceed with the research, and then we can find how many of these 4,200 substances, we've only looked at 37, actually need to be on Schedule 1, and to what extent some of them, don't have a problem at all. And some of them may even be able to get people off the use of drugs, right? That research, this bill doesn't allow for that. There's no off-ramp process. So you'd have to come back again and amend the bill each time you found something like that. Whereas
And
what
it's
we're
so
saying
easy
is
to
with this
amend.
off-ramp, we would put that in the bill,
Right.
as well as the mandatory minimum sentence provisions.
One more quick question. Can you speak, there's been some concern about what this would do to the use of fentanyl test strips. Does this bill have a negative impact on the increasing use of fentanyl test strips, which I understand are really helpful in terms of harm reduction?
Again, I don't know. I mean, my guess would be that once you continue this scheduling, that those test strips might not be allowed, but I don't know the answer.
I don't know.
For that. Apparently, there's another amendment that you have before you today that would, make sure that those continue. So that would
Okay.
be another amendment that we would encourage you to include
So we should
today.
exempt them.
Right, exactly.
All right, I yield back.
Thank you. Gentlelady from Minnesota is recognized for any questions she may have for our panel.
Thank you, Mr. Chair. And there was lots of discussion about amendments when we'll take testimony for amendments later on. So, but I just wanted to point out that, according to the Department of Health in Minnesota, my state, more people die from these synthetics than heroin and prescription opioids combined. And so I really appreciate the fact that this bill is here. And maybe, Chair Griffith, if you could talk a little bit about what happens at the end of 2024 if we don't pass this bill.
Yeah, what happens at the end of 2024 is the analogs are no longer illegal, and you will see ramping up in December of 2024, the cartels will start pushing a synthetic that has the same impact as fentanyl, but would not be illegal under United States law. And so, you know, until 2024, we're protected, and as my colleague says, you know, on that, this doesn't do a whole lot, but it means that we don't have to pass another law down the road, and if it doesn't do any harm and the research part does some good, I think we ought to vote for it. But obviously, there's some disagreement about that.
Well, I appreciate that, and thank you very much, because I think, you know, sometimes we go askew and we're talking about mandatory minimums and all kinds of things that aren't even in the bill. And we need to focus on what the bill is doing and what we're trying to prevent. And we're trying to prevent that issue from happening at the end of 2024. And so I appreciate that, and with that, I will yield back. I just wanted to straighten that up, and I appreciate your bill. Thank you, Mr. Chair.
Gentleman from Colorado is recognized for any questions he may have for our panel.
I thank the chair. A couple of quick questions, well, really a question and then a comment. First, I want to thank each of the sponsors for their testimony today, and of course the ranking member as well for his testimony on a variety of different bills that obviously warrant our consideration. In particular, of course, with respect to the bill that's been offered by Representative Griffith, I co-chair the Fentanyl Prevention Caucus in the House, and so this is a subject I care deeply about and believe, as the ranking member said, that we need to implement a whole-of-government approach on a bipartisan basis to address the scourge of fentanyl that is devastating so many communities across the country, mine included. I wanted to ask you actually a question, not so much about the substance of your bill, but going to a point that my colleague articulated so well, Ms. Scanlon from Pennsylvania, and that is regarding the amendments. I'm sure you've seen there's a robust submission of amendments, and as my colleague on the other side of the aisle mentioned, we're going to have an opportunity to hear from sponsors on that front. I guess I just wonder, your personal opinion, do you think this committee should consider those amendments and have an opportunity to be able to, on the floor, give members an opportunity to have an up or down vote on some of the amendments that have been presented? And let me preface that with saying, I know there are some members on the other side of the aisle who earlier this year, during the process in which this Congress was initiated and the rules were adopted, that made much of supposed rule changes and trying to bring this institution back into a place in which there was open debate, and I count you among them. And I think you've always been intellectually honest on that front. And so I'm hopeful that you might provide this committee with some direction about considering the robust pool of amendments that have been proposed. Because I'm worried that as you exit the room, that my colleagues, unfortunately, on the other side of the aisle may become a bit reluctant.
Yeah, and I will just tell you, you know, when you look at germaneness, there are different opinions on my side of the aisle too, but the reason, and I talked to the parliamentarians about it, the reason I got some language change was so that we could change that rule. It is my fervent belief that we need to change that rule, and that the mechanism that was put in place allows us to change that rule. And what we should be looking at is, does the amendment directly impact what the bill's intent and purpose is? This bill's intent doesn't have anything to do with mandatory minimums. That's a completely different discussion. So I would submit to you that a large number of the amendments are not germane to the bill. And once people start getting used to figuring out how to draft under the new construct, draft those amendments, sure, I think we'll be in better shape. And the best place to start is right here in the Rules Committee. We will probably have some floor fights. I'm hopeful before the end of the year we'll have some floor fights over the defining of germaneness. I mean, what people don't seem to realize is that the precedents that are set are not there to bind us, but to guide us. And what we have done is we've gotten to a point where we're completely bound by precedents that in some cases don't make sense and have gotten too broad. We've allowed too much, in my opinion, on germaneness, which is why I fought to get some rules changes related to single purpose. This bill has a pretty straightforward single purpose. And I think that all of the mandatory minimum amendments are clearly not germane to the purpose and intent of this bill. This bill is about research and about scheduling fentanyl analogs, nothing else, not any other drug substance, not anything directly related to mandatory minimums, and therefore I believe that a lot
I
of
hear
these
you, and
amendments
so,
are not germane.
and I think you answered my question, so a couple of points I'd make. First, with respect to germaneness, my understanding is there wasn't an actual change to the rule, but nonetheless, let's just, I take you at your.
word's changed, just say.
I hear you, I take you at your word, sir, and I guess what I'm asking about are the germane amendments. So there are many amendments that have been submitted by Republican members of your caucus that are germane to this bill. There are a few from Democrats as well, and I'm just asking you if you think we ought to be able to consider those amendments and have up or down votes, because to me, that would be consistent with your worldview that you've
If it is-
articulated previously.
If it is truly and not in violation of single purpose
Sure.
or germaneness, yes.
All right, well, I hope that the chair and your colleagues here will give you the courtesy of, adhering to that wise counsel that you've offered this committee, because there are a number of amendments, as I said, on both sides of the aisle, been submitted by members across the Congress that are germane, that I think merit consideration by the committee. Mr. Johnson, I want to just talk briefly about the CRA. And I guess I want to make sure that I'm understanding this correctly, because I had followed some of the debate in the Senate rather closely, Senator Fisher, of course, being the prime sponsor of the CRA that's now before the House. And my understanding of the argument that they made, I say they, maybe painted with a broad brush here, but several of the Republican senators who were championing this CRA, was the argument that emissions had improved pretty significantly over the course of the last several decades, certainly far different than the trucks that were being built in the 1990s. I assume you agree with that.
I do.
And is it your position that that change has nothing to do with the rule that was promulgated by the EPA in 2001?
What I can tell you is that we have already achieved a 98% reduction in NOx
And why is that?
since 1988. That's a long time before 2001.
Yeah,
And this rule outpaces available technology. The technology is not even there to do what they're proposing.
I hear your argument on that latter point, and I heard your testimony on that front, so I hear what you're saying. I'm taking a step back, because your argument seems different than the argument that was articulated in the Senate. Even in the Senate, the Republican senators, I think, were making the argument that the 2001 rule promulgated by the EPA ultimately enabled the industry to drastically improve the emissions over the course of the ensuing 2 decades, right, 20 years.
I wouldn't dare say that it didn't have any effect, but I would also, without qualification, say it didn't have the total effect. Some of this came from industry.
I'm not saying it had a total effect, but I am saying that the empirical studies and certainly the EPA's data that it's published and your colleagues in the Senate who support the CRA, they all concede that the 2001 rule had a substantial impact in decreasing emissions. And they nonetheless support the CRA for the reasons that you've articulated around technology, and I heard your testimony in that front. But for me, I guess what is a bit confounding is to have folks who bemoan regulation and demand that we don't move forward with this regulation, which we know, based on the analysis that the EPA has done, will save lives, will reduce cases of childhood asthma across the country, in Ohio, in western and northern Colorado, where I hail from, and would save ultimately billions of dollars over the course of the long haul going into 2045, that we shouldn't pursue the rule change because it won't be effective. And yet, they cite as justification the fact that the prior rule that the EPA promulgated in 2001 was in fact effective. And who knew that ultimately it would have an impact, as it did. Ranking Member Pallone, do you care to expound on any of this?
I just want to say this, and maybe I just keep coming here for these CRAs and I'm getting disgusted with it, but I mean, it just seems like, I know you guys are going to take this in the wrong way, but look, we have a committee that deals with all these pollution issues, EPA, health issues, safety, whatever. to me, using the CRA process, which precludes any further regulation in this space, is not the way to proceed legislatively around here. What I'm seeing is more and more Republican, the majority, bringing to the floor these CRAs that preclude, if they were ultimately signed into law, that would preclude us dealing with all these health and safety issues. It's not the way to legislate. I mean, I don't think anyone, I don't think Mr. Johnson is suggesting that we shouldn't be doing something about heavy-duty trucks now or in the future. Yet if you pass this thing and it became law, we wouldn't be able to do that. And I know that's not what you wanted me to discuss, but I mean, I just want to say it's getting to the point where every week there's another CRA, and the consequence of all this, if it actually became law, would be devastating to health and safety for the country.
No, you raise a great point, Ranking Member Pallone, and, you know, Mr. Johnson, to the extent that you would care to respond on this front, I would certainly welcome it. I mean, well, let me give you a question here and throw it your way, and then you can respond, because the Ranking Member raises a really interesting point. Sitting on this committee, we've done a lot of CRAs. It has been a CRA-intensive start to the 118th Congress, which I suspect some folks on your side of the aisle take pride in. And what I would say is I started, you've served in Congress long, I'm looking at Mr. Massey, you know, it's big thumbs up, but I started my tenure in Congress in the 116th Congress. You've served, of course, longer than I have. When I started in the 116th Congress with my colleague, Ms. Scanlon, Donald Trump was president, as you might recall, 2019. The president, the administration, had promulgated hundreds of rules across a bevy of different federal agencies during the preceding 2 years. Do you know how many CRAs we considered in the 116th Congress? You and I.
Wow.
18 CRAs? Two CRAs in the 116th Congress. Two. So, again,
I'd have to go back and look.
you can check the notes, and you know, we'll be here for a while. To Ranking Member Pallone's point, you know, the CRA is a hammer, right, as opposed to, you know, a finely tuned scalpel as we're addressing some of these really nuanced policy challenges. And I think they are best reserved for thoughtful consideration in the subcommittee that you chair, in the full committee that Ranking Member Pallone serves on, rather than just doing a CRA basically every week. I mean, it's got a lot of challenges that we're facing as a country. Would like to be able to consider legislation like your colleague, Mr. Griffith's legislation on fentanyl, which I appreciate, you know, him bringing forward in front of this committee. So anyway, I'm happy to give you a chance to respond, but
Yeah.
of course.
Well, first of all, let me say that the CRA process, I think, is there for a reason. It's part and parcel to Congress's oversight responsibility of the administration, and sometimes, given the criticality of the issue, I think a CRA is the appropriate way to go. And quite honestly, I've been here for 13 years. I don't think we've considered that many CRAs since I've been here in 13 years. And the ones that we did were very important ones. The other thing that I would
From
like to
19,
point
if
out,
I might just comment there, I'll give you a chance.
if I might finish.
Sure.
One of the main reasons why this one is so important is because the rule is not going to accomplish what the EPA is trying to accomplish. They've admitted that this thing is going to cost somewhere between 39 and 55 billion, which the cost is largely going to be borne by the American consumers, because small and independent truck fleet owners are not going to be able to afford to go to these newer trucks with the $8,000 cost associated with them, or the $2,000 for the F-250. And so they're going to stay with the old technology, so we're going to keep the old trucks on the road longer, and so we're going to actually slow down the process of reducing NOx emissions.
And I hear your argument, Mr. Johnson. The EPA clearly has a different view, but with respect to the CRA, just because you're actually right on this point. I don't know how long you served in Congress. I know, again, this was longer than I have, but CRA was adopted by Congress in 1996. It wasn't used a single time until 2017. So you're right. for the vast majority.
Yeah, I was the one that introduced it, to get rid of the string protection rule, and I'm sure as hell glad that I did.
Well, and look, no one's making that case. No one's arguing that the CRA isn't a tool that should and can be used by the Congress from time to time. What I am saying is that the House Republican majority has chosen to spend its very limited floor time on 6 CRAs over the course of the last 4 months, which is 3 times the amount of CRAs that were considered when House, hold on, Mr. Johnson, I let you finish, I'm going to finish my statement, that House Democrats utilized during the course of the final 2 years of the Trump presidency. And so, look, I mean, I go back to Mr. Griffith's comments about, I think returning this place to regular order and applying sort of an institutionalist view to the Congress. If this is the system, and we're just going to have a Congress, as it switches back and forth and the political winds shift, and we'll consider 10 to 20, 30, 40 CRAs every year, depending on which party's in power, I guess that's the system that some would like to adopt. I don't think it's a particularly productive system. That's the point I'm making. With that, Mr. Chairman, I'll yield back the balance of my time.
Mr. Chairman, may I respond to that last?
I'm happy to, I'm sorry. Yeah, I'm happy to yield to you, of course.
I would say that there is certainly a time and a place for CRAs, and I think one of the reasons why you see this one, and I'm sure this is going to generate a lot more discussion, we had the best economy that we'd had in 50 years under the previous administration. Today, we got the highest inflation that we've had in more than 40 years. There's a reason to pull back on the regulations coming out of the Biden administration, and the CRA is a valid way to do it, and that's what we should do.
Well, I will just say, since we're here on the dais and we like to have the last word, because I wanted to give you an opportunity, but the response I don't think was germane to the argument that I was making. So I will simply conclude by saying it seems to me that your view, pretty clearly, is a CRA a month, 2 CRAs a month, 3 CRAs a month. We should just keep doing CRAs, and that is fine. You're entitled to that view. I don't think it's a particularly productive way for us to do our business. We're going to have an opportunity in a minute, Mr. Massey. Why give you that time now? And again, we could talk about the merits about the rule as well, as I said, and the various ways in which I think it will benefit the American public. Obviously, we have a disagreement about that on the merits. But with that, I yield back, Mr. Chairman.
Gentleman from Kentucky is recognized for any questions he cares to pose to the panel.
I thank the chairman. Let me just point out, if we had the REINS Act, we wouldn't need so many CRAs. And also, I think it's Congress asserting our responsibility to legislate. I mean, what we're doing when we pass the CRA is saying, no, well, the executive branch has expressed an opinion to make something have the force of law, and we're saying, no, thank you. We'll go about doing that job, which was given us in the Constitution, given to us. It's not very often we have a rule that deals with fentanyl and truck motors at the same time. Maybe we could get the truck motors to run on fentanyl if it's so concentrated. But let me start with the truck part of this. I've owned an F-250 for 26 years, the same F-250 actually, and I've owned an electric car for 10 years. And I went to buy another F-250 for my farm, haul cattle, hay. And I thought, well, let's look at the electric ones. They don't make an electric F-250, and we'll get to why here in a bit. It'll be obvious. But I could make an F-150 work, and they make those electric. You can't get to the stockyards and back in an electric car or in an electric truck. It's not practical. It's the F-250 and the comparable trucks that are made by GM and Dodge, those are the meat and potatoes of entrepreneurs. If you look at what is the backbone of what they use to get the job done, it's going to be a 3/4 ton or a ton truck. Farmers, this rule that the administration has promulgated is very regressive. As you said, Mr. Johnson, it's going to hit the farmers, the landscapers, the home builders, the surveyors, anybody that needs a professional truck is going to be hit by this at a time when it takes a year sometimes to get one of these trucks. They're in such high demand, and it's so hard to produce them with the supply chain we've got. Can you talk a little bit, Mr. Johnson, about why this rule is regressive, to have the same thing apply to semi-tractor trailers that applies to a farmer's truck?
Well, absolutely, and regressive is a very good word, because as I mentioned earlier, when you're talking about small operators like farmers, like the independent truckers, even with the 18-wheelers, independents that own maybe one or two trucks, and that's their livelihood. The owner-operator is sitting in the cab of that truck, operating it day in and day out. They're not going to be able to afford to go to the new technology and spend the $8,000 that's required. They're going to stay with their old truck, because you can get a lot of miles out of these trucks. You can keep overhauling the engines. You can keep working on them. They'll go for a long time. You're going to keep the old technology on the road, but you're essentially going to continue emitting NOx from those vehicles, because the technology to do what the EPA is suggesting is not even there. It's very similar to what they're trying to do with carbon sequestration. I'm not against carbon sequestration, but it hasn't been adequately demonstrated yet. And when you talk to companies that have to put carbon sequestration on their power generation plants or on their manufacturing plants by 2032, 2035, by 2040, if you don't have it, you can't operate. Those kinds of things, you're not going to accomplish ultimately what you're setting out to accomplish.
And I think you made a great point just now and earlier about unintended consequences. This is going to have it's going to have a different effect that's 180 degrees in the other direction from what they intend. If you don't see a lot of F-250s and F-350s in Washington, D.C.
Yeah.
You might see somebody come from Virginia here to remodel a bathroom, okay, but or you might see the Capitol architect have them. But other than that, you just don't see them here because we don't make anything in D.C.
Well, here's the kicker: $39 to $55 billion. When that 18-wheel truck driver spends $8,000 and buys a new truck to do that, who do you think he's going to pass off that increase in cost to?
Well,
to the person that he's hauling for.
So it's going to hit the 18-wheelers and the independent owner-operators, which Mr. Pallone said there was nobody. Did you say, I don't want to put words in your mouth, you said the industry's not opposed to this, Mr. Pallone?
Well, what I said is, generally speaking, we didn't get much opposition from the industry. I mean, in fact, the matter is that the industry usually brings a lawsuit, and they didn't do it in this case. Not that that's an only indicator. But I mean, I do want to say, maybe, I don't know if this answers your question, but, the final rule has all kinds of protections for small business owners in the trucking industry and flexibilities for compliance that were negotiated with the industry. I don't want to go through them all, but for example, longer useful life periods to allow manufacturers to improve durability of emission-related components, increase emission-related warranty periods to ensure better performance, also the period for filing a petition. I mean, there's a whole bunch of things that were done in order to try to accommodate small businesses, but I'm not familiar enough with trucks the way you are to comment on all these things,
I thought I heard you say a couple times that industry wasn't opposed, and then I heard Mr. Johnson give a list.
They may, I'm not going to dispute his list, but the fact of the matter is that there was a lot of negotiation with industry, and I think if you went back to those groups, they would say, yes, we had a lot of input, but maybe they still don't like it.
Let me ask Mr. Johnson to rebut that. Can you give us a list of the industry?
What I said, Mr. Massey, was that there have been significant groups that are supporting SJ Res 11, which is the CRA, to reverse this rule. The American Trucking Association, the Owner-Operator Independent Drivers Association, Transportation Intermediaries Association, the National Tank Truck Carriers, Truckload Carriers Association, National Federation of Independent Businesses. They represent thousands of small business owners across the country. So I think there is significant indication from the trucking industry across the board that they support reversing this rule.
And I would add to that list American Truck Dealers and Truck and Engine Manufacturers Association,
And at least one farmer.
and at least one farmer, if not millions of farmers. Another unintended consequence, you know, when you're on the interstate, and I've recently been driving back and forth from DC to Kentucky, you notice as many of these small carriers, F-250s, F-350s, typically a dually, carrying pulling a trailer behind it, a gooseneck trailer, they are carrying what would be less than a full load for a semi. If we regulate those smaller trucks out of existence, you're going to have the bigger trucks carrying a load that's a quarter of their capacity, emitting more than the smaller truck does now. You know, if you had a brand new truck under these regulations, a semi-tractor trailer truck that's hauling practically an empty load because there's no other way to get from A to B because we've regulated the little guys out of business. They call this niche is called hot shots, where they use a dispatcher just like the big trucks, and they find loads and they go get them, and they do it very efficiently. And it's one person that typically own their truck.
You're right.
Trailer.
You're right.
So when they're gone, we're going to have semi-tractors that are a quarter full. So I support the CRA to repeal this. We really should be writing these laws ourselves and not leaving this up to, this is in the tens of billions of cost. I can understand if it's just a little adjustment to some law that we wrote. That's not what this is. This is making it from whole cloth. I won't go on any longer on that, and I have just a very quick question on fentanyl for you, Mr. Griffith, which you might have anticipated. Where in Article 1, Section 8 do the founders give us the authority to pass a bill like yours?
Specifically, which portion?
Well, your bill regulating fentanyl or synthetic versions of it, you know, we have certain enumerated powers, and which of those enumerated powers are you relying on to promulgate this law?
Well, and the gentleman raises a good question. That's not the purview of the bill. You raise a good question, but we'd have to throw out a lot of laws if we don't have authority to do this one. You're probably right, but I'm not here to fight that battle today, just like I'm not here to fight the battle of mandatory minimums today.
Okay, that's all I wanted to hear, and now that I've heard I was right, I will yield back.
Gentlelady from New Mexico is recognized for whatever question she cares to pose to the panel.
Thank you so much, Mr. Chairman, and thank you for presenting here today on these two issues. And, you know, I was going to congratulate our colleague, as we all might know, from Colorado. His new baby, Joshua, came this weekend, and his big sister, Natalie, is important. So I'm sure as he's sitting through these things, he is thinking, and we are all thinking about the children, right? Because what we need to always think about is how are the laws that we are passing, and how do we consider the work that we are blessed to be able to do here in DC, how is that impacting our children? And I think that the two bills we are talking about today very much impact our children, our communities, in two different ways. And I think there is a connection between them because we know that fentanyl is being brought into the United States by despicable Americans who are crossing our ports of entry in vehicles, often in trucks. And I think that we need to be very clear that there is, I don't think, anybody here in Congress who isn't dedicated to eradicate the scourge of fentanyl that has impacted our communities. And then I think we get to, but what are we doing, right? And this is where we might have some disagreement because we're very concerned, as you know, that right now as we're struggling to address all of these various issues, the Republican majority is holding our country hostage to force passage of certain funding cuts, and that those funding cuts, if applied evenly, will have a really big negative impact with regards to fentanyl on our ability to treat addiction. And I think that when we look at this bill, Chairman Griffith, I appreciate the fact that you want to address fentanyl. And I don't have a complaint about the fact that we are addressing fentanyl. What I worry about is that we are not addressing fentanyl in the many areas it needs addressing, especially with regards to treatment, especially with regards to the research into what can we do to make sure we better track, better test, so people aren't unwittingly dying from fentanyl when they had no intent of ingesting fentanyl. And we read article after article about that. And I don't think adding those provisions to this bill would make it unwieldy. I think they are very much tied in because, as my colleague, Representative Scanlon noted, we've been doing this for a while. And we realized some time ago that just having an enforcement-only approach does not work, that you need to look at what is it doing in your community. And I guess, Chairman Griffith, do you agree that treatment of fentanyl, the public health issue, is something that, as a country, we need to address?
In another bill, absolutely. This is not the bill. We have hearings coming up in the Energy and Commerce Committee related to dealing with treatment, et cetera. But we can move this bill forward, hold those hearings, and we can look at another bill another day. And one of the problems that we have in getting something that's comprehensive is we get tied up, fighting over big things, and we don't get anything. And this bill represents an opportunity for us to get something done for the American people.
So is it correct then, though, that your committee has jurisdiction over these matters? You can address these issues, and they can be addressed in a bill. It could be addressed in this bill.
It could be addressed in a bill, but not this bill.
Yeah. This bill could have handled them if any of the amendments would have been adopted. Ranking Member Pallone, what are some of the amendments that you think would have been very useful in making this bill not unwieldy, but actually focused on the problems that we are facing in my community and in every single community across our country regarding fentanyl?
Well, I haven't looked at all the amendments that are before you, but, I mentioned the Pappas Amendment, which is bipartisan, that adds these provisions that the President's task force had recommended, in terms of an off-ramp, in terms of not having mandatory minimums unless it's a serious offense, in terms of, well, there's a bunch of things that I mentioned. I don't have to repeat them. Also, I think Ms. Scanlon talked about the strips to test drugs for fentanyl availability, and that's the Crockett bill, amendment number 59, that is before you. Look, we in our committee, as you mentioned, we reauthorize and fund the Support Act, which includes treatment programs, so that could obviously be done. Medicaid, I've been trying to do a Medicaid policy for a number of years that includes a lot of the things that you suggest. The bottom line is, and I know I just feel like I keep repeating myself, right now, these fentanyl analogs are included under Schedule 1 for the next 18 months, right? We're not really doing anything in this bill other than extending that, which we've done, and making it permanent, which we've done many times, right? And there's no reason to believe this is going to do anything to address not only the treatment, but even increase law enforcement or anything to prevent overdoses. So, I don't want to, I know Mr. Griffith keeps saying this is a small step, but I would argue that it's like really not much of a step at all because it doesn't really do anything at all for the next 18 months other than extend the status quo beyond that. The things you're mentioning are ultimately much more important.
Right, and I think that when we have an opportunity to address something, that we should look at it. When those building blocks are in front of us, when they've actually been handed to us, when they say, here is a building block, using that, I think it's a great metaphor for all of us who have children who love to build things, right? That was a great metaphor to use, Chairman, because it is a building block, except for that those building blocks are before us now, and that here in Congress, we don't always have a lot of time. I'm learning time on the floor and time in this committee are some of our most valuable resources. And so when we have amendments which would say, let's encourage education of stakeholders around fentanyl, let's encourage treatment with the substance abuse prevention and treatment block grants that Representative Ballant suggested, Representative Blunt-Rochester's amendments to increase education. These are all things that could be done easily. They're the blocks that we are refusing to pick up and that I think our communities want us to pick up. They want us to do more than just codify the status quo. And I do think that codifying the status quo is important. So I do agree on that, but I do believe that our communities are asking more from us. I wanted to move to the next item, Senate Joint Resolution 11, which in my mind will roll back important progress we've made on environmental issues. Because, you know, when families and kids aren't sick or paying medical bills, right, what they're doing, they're going to school, they're going to work, they're investing in their community, and we know that this bill will have a significant impact on public health. Ranking Member Pallone, can you tell us what some of those impacts are?
Well, I mentioned before, and again, I think you're bringing up a very good point, which is that, and Mr. Johnson talks about the cost to the individual who might, who has a truck, and I think we have tried to accommodate that with this rule. But the purpose of the EPA is to address public health, right? Public health and safety. So it's estimated, I may be repeating myself here, but it says that the final standard, this is what the EPA estimates, that the final standard will prevent each year between 860 and 2,900 fewer premature deaths, 6,700 fewer hospital admissions and emergency department visits, 18,000 fewer cases of childhood asthma, 3.1 million fewer cases of asthma symptoms and allergic symptoms, 78,000 fewer lost days at work, and 1.1 million fewer lost school days for children. Now, again, I hate to talk about these things just in monetary terms, but all these things involve money, right? Because the cost of keeping people in the hospital, the cost of going to the doctor, the cost of swimming, all these things add up. That's where the EPA comes up with this figure of $200 billion saved. So even if you take Mr. Johnson, I think he said that would cost an extra, I don't know what you said, 37 or 57 billion, 39, but can't contrast that with the $800 billion cost of all these terrible things that would happen to people if we didn't do this.
And in New Mexico, this is a major issue. We have many children. We have very high rates of cancer. Very high rates of asthma. Chairman Cole, I would seek unanimous consent to enter into the record the January 13, 2023 report about clean truck rules in New Mexico and what they would deliver in terms of $3.3 billion in benefits and avoiding 28,000 illnesses.
Without objection.
Thank you very much. And I think that these are key because our communities want us to keep them healthy, right? And when you have this kind of benefit, it's hard to say no. And with regards to the idea that we are best suited in a hearing that takes, I don't know, we'll spend maybe 30 minutes on this, the CRA objection overrule. 30 minutes is not a lot of time when you are thinking of overruling something that took years and tons of comment, lots of negotiation between the industry and the EPA, looking at small businesses, looking at how do we have protections for small businesses. So to have us in 30 minutes just say, it's all done with, I just do not think that that is the right way to go, that we need to have and look at the expert testimony that has been developed as part of this rule. So with that, Mr. Chair, I yield back.
Thank you, Mr. Chairman. Chairman, I want to thank the witnesses, to taking your time to come here today. I'm not going to spend long on this. Congressman Johnson and Congressman Griffin, these are common sense legislation. It is hard for me to sit here and listen to, on the fentanyl problem, to say that we're thinking about our children, we're thinking about the treatment, we're thinking about the tracking. As a DEA agent told me, in the morgue, there are no treatment centers. There are no tracking systems. There are no education systems. And for one party not to say one word about what's going on at the border, to not stop the fentanyl that's coming in, you can say all the words, but your actions prove you don't believe it. You can say it, but you don't believe it. This border crisis is an invasion, and it's a tragedy that this country is having to go through what this administration has put this country in. And Ms. Johnson, I've gotten my CDL license. The truckers that are under severe strain right now to deliver food, 97% of the truckers are small companies with 10 trucks or fewer. And, you know, with what's happening now with the truck industry, the car industry, when Taiwan goes, which this administration will allow, the semiconductor chip will be in scarce supply. How's that going to work out? And there are no battery-operated dump trucks that deliver materials to our job sites. There are no battery-powered trucks that deliver our food. And now, I now believe, and I didn't for a long time, this administration is intent on destroying this country economically at every level. You cannot do what's happening. And I don't know how you walk it back, to be honest with you. I don't know how you walk it back. When the 15 million illegals come in, when the CDL, the truck drivers go broke over some insane EPA mandate. So I don't want to belabor the time. Thank you all for what you're doing and bringing it. It's good legislation, and I yield back.
Thank you, gentlemen. The gentlelady from Indiana is recognized for any questions she cares to put to the panel.
Thank you, Mr. Chairman. Thank you for coming to testify today. My State of the Union guest was a sheriff from Dearborn County in my district. He told me firsthand that police officers in the district are left picking up the pieces of the fentanyl issue. I have to agree with my colleague from South Carolina. I'm really surprised that we're not talking about the flow of fentanyl from our colleagues on the other side of the aisle coming through not just the ports of entry, but also in the unimpeded, unsecured southern border. To put this drug problem in perspective, and I've mentioned this before, but I certainly think it's worth repeating, our state, Indiana, has a tracker for opioid and fentanyl-related overdose deaths. 220 of my constituents in the 9th District have died from drug-related deaths in the last year alone. That's 220 sons, daughters, mothers, fathers, and family members, when even one is too many to lose. Representative Griffith, in the fact sheet that's accompanying your bill, I noted that 77% of adolescent overdose deaths in 2021 were related to illicit fentanyl. It also listed 109,000 people dying of drug overdose. That was accounted for, fentanyl accounted for nearly 75,000 of those deaths in 2022. I just want to give you the opportunity to tell us what you think the single greatest need is to pass your bill.
Well, I think we need to make sure we get the votes, but the purpose of this bill is to make it harder on the bad guys, the drug dealers, and the people bringing these substances across the border. And the way to do that is to make it so they can't cook up new schemes and new ways to get around the law. And then secondly, to have the research. It is hoped, although there's no evidence yet, but it is hoped that one of these analogs might be an antidote to the overdose, because unfortunately what's happening is that the fentanyl is being put into a lot of other substances that people, you know, like so many other drug scourges that have come through in the past, people went out and looked for it. Here, oftentimes what's happening is they think they're buying something else, marijuana, Percocet, something else, and it's laced with fentanyl and laced at a level that's fatal. And so what we're trying to do here is to make it harder on the bad guys and do the research to see if there is something out there that might be an antidote to all the deaths that are happening.
All the chaos.
All the chaos, yes, ma'am.
I want to talk just a little bit about mandatory minimum sentencing. That's been brought up a few times here today. I just want to note that mandatory minimums were established in the 60s and 70s when there was virtually unlimited sentencing, unrestrained discretion, which led to well-documented sentencing disparities in cases that were factually substantially similar. Mandatory minimums, we've heard, have created some racial disparities. However, mandatory minimums don't take race into consideration at all. In fact, it doesn't tie the crime to the person, or the person, it doesn't tie the sentence to the person, it ties the sentence to the crime. Also, we've heard that mandatory minimums have had no effect. However, in the 1990s, a significant drop in crime across all categories of offenses was tied to mandatory minimums that were adopted in the 1980s, which contributed to that decline. Mandatory minimums were created by the U.S. Sentencing Commission to promulgate sentencing guidelines to address the very issue that our colleagues on the other side of the aisle claim are happening under mandatory minimums today. Mr. Pallone, are you opposed to all mandatory minimum sentences?
As a general principle, I don't think it's a good idea because I think that's why we have judges to assess each case.
So there was a mandatory minimum for armed career criminals. Are you familiar with the Armed Career Criminal Act?
No, I'm not.
So that imposed a minimum 15-year prison term for anyone convicted of being a felon in possession of a firearm if they have 3 prior convictions for a violent felony or serious drug offense. Do you support a mandatory minimum for the Armed Career Criminals Act?
I'll just repeat what I said before. That I mean, generally speaking, I think that we should leave sentencing up to the judges and not dictate it.
And one of the issues that has been brought up with respect to mandatory minimums has been that it's not essentially judges' discretion that comes into play in many of these cases where there have been racial disparities, even in cases where mandatory minimums are in play. It's prosecutorial discretion in the plea agreements that lead to sentencing disparities. Over the years, mandatory minimum sentencing has been used to reflect a societal judgment that certain offenses demand a specified minimum sentence and argue that anyone who commits such a crime cannot avoid a just punishment as determined by the mandatory minimums. In 2021, 48,830 people died of gun violence. And again, I want to note that the Armed Career Criminal Act had imposed a minimum 15-year prison term for those convicted of being a felon in possession of a firearm with prior offenses. Fentanyl, however, accounted for 325,000 preventable deaths in 2021, a 20% increase over the prior year, and again, approximately 75,000 in 2022. So more people are dying at the hands of drug dealers pushing fentanyl on our streets than died of gun violence. And our colleagues across the aisle want to talk a lot about things we need to do to prevent gun violence. However, many of them don't support the mandatory minimum sentencing in this piece of legislation, which I do support because I think it doesn't take race into account at all. As I mentioned before, it ties the sentence to the crime and not the individual.
So if the gentleman would yield, I would point out, though, that what I had suggested in this amendment that I would like you to adopt by Mr. Pappas and some of the Republicans is that it would say that with regard to offenses resulting in serious bodily injury or death, there still would be mandatory minimums.
So there are certain cases, Mr. Pallone, where you would support mandatory minimums?
That's a compromise, if you will, that's been suggested by the Biden task force on the topic.
Okay, thank you. I want to switch to the trucking piece of this bill. I have no questions for the witnesses, just a statement that trucking is vitally important to my home state. Indiana is known as the crossroads of America, and truckers and their trucks are certainly a big part of our state's economy, in particular the rural communities that I have the privilege of representing. I'd like to submit for the record, Mr. Chairman, a statement in support of SJ Res 11 from the American Trucking Association, which is similarly supported by the Indiana Truckers Association.
Without objection.
That's all I have. Thank you to the witnesses for your time. Mr. Chairman, I yield back.
Thank you. The gentleman from Texas is recognized for any questions he cares to pose to our witnesses.
I thank the chairman. I want to thank my friend from Virginia for bringing forward this important piece of legislation. I think, as the gentleman knows, it is impacting the entire country. Obviously, it's impacting Virginia, rural Virginia in particular, where the gentleman hails from, but also Texas in fairly significant ways. Just 2 weeks ago, I met with 3 moms. There are 3 more moms of the dozens, probably hundreds now, that I've met with who have lost their children to fentanyl poisoning. Now, all of us as members of Congress have run across and met with constituents who have had this occur. What I would suggest to some of my colleagues from around the country, it's becoming a daily occurrence in Texas. We've had 5 children in Hayes County, where I live, just southwest of Austin, die from fentanyl poisoning since last August in the school district my children would go to, were they not at a Christian school, which is where my wife and I have chosen to send our children, after she and I were both public school educated, K through law school. In fact, the reason I was slightly delayed today was because my children had Ephesians Chapel today, where grades 1 through 6 recite all of Ephesians from memory. And it's a great day of celebration at the last week of school every year. My daughter's in 6th grade and recited chapter 6, as they do, as they go through all of Ephesians. And that is why I'm late. I had to take the later flight after listening to the recitations. But I can tell you, in talking to parents in public schools, private schools, throughout all of Texas, but predominantly and in the area that I represent, San Antonio, Austin, the Hill Country, where my colleague, Mr. Gonzalez in South Texas represents, a lot of the small towns between the border and San Antonio, and he represents part of San Antonio. It's absolutely devastating families. And it shows no sign of abating. And I just wanted to make sure that, because I know there was some discussion here, I was getting some updates as I was coming in, that there was, discussions about this being, carried out and perpetrated by, evil and terrible Americans. I don't disagree with that. One of the moms I met with, that her child had this sold to her child from, a drug dealer there in Hayes County, an American. We had an American citizen who was being paid by the cartels, an employee of the cartel, to move human beings into smuggling, into a stash house when we busted them in Bernie, Texas, outside of San Antonio not long ago. And that's what we see all of the time. However, what is missed in that is the extent of what I just said. You have an American citizen, employee of a cartel. You have American citizens tied directly to cartels. Yes, very bad actors in America, but driven heavily by cartels. I assume the gentleman from Virginia who's introduced the legislation, and I thank him for doing so, is aware of the extent to which the Chinese Communist Party is engaged in operating with cartels in Mexico to carry out the movement of dangerous fentanyl into the United States, knowingly and intentionally, including equipment sales to the cartels to print and make the pills in question, including providing the precursor materials, which obviously you are trying to deal with in your legislation. And I assume the gentleman is aware, like I am, of that significant connection, number one. And second question, I assume the gentleman is also aware of the extent to which Border Patrol is unable to fully patrol the border. Even right now, when the President of the United States stands up and says, it's better than you expected, he said. We still have 4,000 a day being processed, which you remember that Jay Johnson said 1,000 a week was a crisis. And we have 4,000 a day being processed. The Border Patrol processing people, they are unable to patrol between the ports of entry. So our knowledge of what is occurring and what is being trafficked between the ports of entry is pretty low. And again, those two questions, I assume the gentleman is aware of those things and would agree with those 2 points.
I concur.
I wonder if either of the other witnesses have anything to add about the extent to which the Chinese Communist Party is fully involved with cartels to move dangerous fentanyl into the United States and exploit our border, which is unable to be fully patrolled by Border Patrol in order to stop said flow of fentanyl into the United States.
I would assume that the Chinese Communist Party will do whatever it can to undermine and kill us.
True.
I would agree.
And to the extent to which our border is unable to be patrolled by Border Patrol, that is in fact a national security risk and a direct cause of harm to the American people if Border Patrol is unable to actually patrol the border to try to minimize and stop said flow of fentanyl into the United States. Would that not be a problem? Ask all the witnesses.
Well, one of the things that I was saying earlier, though, and that we had a discussion about, is that there's nothing in this bill that increases funding for either treatment or enforcement. I mean, in my opinion, all the bill does is to continue the status quo, and it's not going to actually make a difference in terms of interdiction or overdose or deaths, because it doesn't provide any additional funding for enforcement or treatment or any of those other things.
Well, we just passed HB2, which does in fact have additional resources for Border Patrol to be able to stop flow at the border, of course, tied to the policies, which would actually have an even more dramatic impact on the border, because we would, I don't know, what's it called, actually enforce the law, which would actually, discourage people from flowing across the border. I wonder if the gentleman from Virginia has a response to the "this bill won't do anything" charge.
Yeah, and it's just not accurate. The bill does two things. One, it makes the current ban on analogs, the scheduling of Schedule 1 on the analogs permanent. That stopped both the Chinese sending over the refigured chemistry, and it stops the cartels from using that refigured chemistry. It became unprofitable or not worth the time and effort to find the additional analogs because of the temporary ban. Making it a permanent ban will put that off the table forever, and you'll take that out of the way. That frees up a lot of our Border Patrol agents and other law enforcement agents. They don't have to learn new tests for every analog. They just have to see if it tests positive for fentanyl. So while it doesn't have any money itself, it makes it cheaper permanently to enforce the current law. And then we have the whole research component, which may lead to some kind of a solution. It may not, but it allows the universities to do research on fentanyl analogs to see if there's any medical efficacy to having them, and then creates a way to make it so that those can become usable for medicinal purposes.
I appreciate the response to the gentleman. I assume the gentleman is aware of the numerous instances where obviously people are being killed by virtue of getting drugs that have fentanyl laced in it, but they believed they were taking something else.
Yeah, that's a serious problem that needs to be dealt with as well. And so, as I told folks earlier, this is a building block. This is not the bill that's going to solve all the problems. I don't think we could have a single bill that solves all the problems. And then we got into a great dissertation that you would have enjoyed on germaneness.
Well, I'm sad I missed that, but I no doubt with you in the room it was answered. And so
I just created more controversy, but that's typical.
Well, look, I'm gonna turn it over to my friend from New York, but I would just say, every single day in Texas, say what you want about the politics of the border. Say what you want about, what you want in terms of future immigration flow, what you want in terms of amnesty. What we're experiencing in Texas is an absolute devastation of our state and our people and our communities by virtue of the failure of the federal government to actually do its damn job and secure the border of the United States. That is an undebatable point. It is a fact, and we're taking it on the chin. And I can promise you, we, the people of Texas, aren't going to just sit back and keep taking it on the chin. We have something we're going to have to do about it, and we're starting to. DPS is sitting down at the border with razor wire and agents doing the job of the Border Patrol because the Border Patrol is not being allowed to do it because our people are dying. And I'm getting sick and damn tired of my colleagues on the other side of the aisle not giving a whit about not only our own people, but the rest of the states having to pick up for the fact that my Democratic colleagues refuse to actually give a rat's rear end about what's happening to Texas. Because if I have to read another headline in Bexar County, right, of, well, we got fentanyl-laced issues, the DEA warning of the parties in Fiesta in April of 2023, Comal County, New Braunfels police seized 6,500 fentanyl-laced pills worth $195,000. Travis County, 1,000% increase in fentanyl deaths in just 4 years. I could go through list after list after list, name after name after name, mother after mother after mother, and it is a direct correlation. I'm not saying it's the only issue, a direct correlation to a border left wide open and exploited for the Chinese Communist Party to work with cartels to endanger our people. And we should damn well do something about it. And I appreciate the gentleman from Virginia for taking one step forward to try to deal with this scourge. I yield back.
Chair, thanks. The gentleman. Chair recognizes the gentleman from New York.
Thank you, Mr. Chairman, and I just want to first thank the witnesses for being here today, and I can't agree with the gentleman from Texas anymore with his sentiment. And thank you, Representative Griffith, for bringing this legislation forward. Can you please elaborate on how H.R. 467 addresses the issue raised by our colleagues on the other side of the aisle who believe that this legislation would prohibit access to fentanyl for medical purposes or prohibit research?
Yeah, they're mistaken about that. It does not affect fentanyl itself, only the analogs, and what the doctors are using is fentanyl for medical purposes at this time. They're not using the analogs. The only people that ever came up with the analogs were the bad guys trying to get around the criminal penalties for bringing fentanyl into this country or for distributing fentanyl on the streets of our cities and our towns, our villages, and our rural counties. So that is not accurate. What was the second part? I know there was a second part. I forgot it.
For research purposes.
Oh, and look, one of the things I've always advocated is that we do more research on substances. I mean, we got into a real problem with marijuana where the universities couldn't research it, and so we don't really know. We've got all these states that have now made it legal for recreational purposes, and we don't know what the long-term effects are of heavy use of marijuana on somebody's physical health or their mental health. So one of the things I've always advocated is that we have a research component, which is why it's in this bill, is that we can research those analogs. If there are scientists or doctors or folks who feel that there's something an analog might be able to do that's helpful from a medicinal standpoint, our universities are authorized to be able to do the research, obviously being registered with the appropriate authorities.
And during the temporary scheduling, did the pharmaceutical industry or researchers or any other relevant entities express concern that the scheduling prevented the development of new medicines?
I haven't heard of any specifically. I know that NIH and some of our other institutions have done some research, but I haven't heard anybody, and there may be somebody out there, but nobody has said to me, we haven't been able to do the research that we wanted to do during the temporary. But if they do want to do it, we're making that available.
Yeah. Thank you. What impact has the emergency scheduling of fentanyl-related substances and the bipartisan extension of the scheduling that was included in last year's funding package, what has that had on the availability of these substances, particularly from China?
Well, it's completely shut down the analogs. I mean, that is not a concern at this point as far as smuggling it in because the penalties are still there for fentanyl, but there's no advantage. The reason that they were coming up with the analogs is that there was an advantage. You could go into court and argue that it wasn't illegal. And the two, and I can't speak for the Democrat lawyers, but the two Republican lawyers have been very adamant, myself and Kelly Armstrong on the Energy and Commerce Committee, that if we don't do this permanently, what we're doing is we're setting up a situation where somebody happens to fall in between the cracks of the times that we have the temporary ban in place, they can argue that what they were selling was not illegal. That made a profit motive for both the Chinese and the Mexican cartels. The Chinese making either the API, the active pharmaceutical ingredient, or making the pill itself, or the cartels for transporting it. It's a benefit for them if we don't have the analogs scheduled as Schedule 1, and that's where the reason they were coming up with these different analogs, was to avoid the American criminal penalties.
Very good. Now, I've heard, and I know Mr. Roy touched on this for a moment, but you know, I've heard our colleagues across the aisle in this hearing suggest that this legislation is just a continuation of the status quo. I mean, just for a final point of clarification, is this a status quo bill?
No, it's not. It does two things. One, it makes it permanent. Instead of every 2 to 3 years having to come into Congress and pass a new bill, which we've done since 2018, we've come in every so often and passed a new bill making the analogs illegal, because we recognize that that's a serious problem. And none of those bills that extended it dealt with minimum mandatories, by the way. But we've extended it till 2024. So in that sense, you know, you could say between now and the end of in December 2024, it doesn't change that part. But the whole thing about the research and allowing research, if there is a medical reason for using an analog, our NIH and other researchers may be able to find it. I don't know that they will. I'm skeptical that they will. But it gives them that opportunity instead of saying you can't look at it. And right now, other than the government agencies, I don't think any of our universities can do any research on the Schedule 1 substances. In fact, I'm pretty sure that. Anybody, am I right on that team? All right. I think I'm pretty sure I'm right on that. But they can't do it on Schedule 1 substances. This would allow them to do research on Schedule 1 substances for purposes of determining if there is any medical purpose or use to an analog. Again, I'm not sure that that's true, but this is a huge step forward if there is something. And what we really want to look for is an analog that acts as a blocker to the impacts.
Very, very helpful. Thank you, Representative Griffith. I appreciate you sharing and reiterating this point for the committee, particularly to my colleagues across the aisle who seem to forget that there was and continues to be a tremendous amount of bipartisan support for this straightforward and life-saving measure. And without Congress acting now, we will continue to face the same very real possibilities that the emergency scheduling begun by the DEA in 2018, a measure that has shown great results, will expire. Just last week, in this committee, we worked to report several bills in support of our local, state, and federal law enforcement officers. These men and these women who are working to keep our communities safe, and they're doing so while Democrat-run cities and states continue to defund them, malign them, and villainize them. I see this legislation before us today as an extension of the work that this majority is doing to support our law enforcement officers and our first responders. And people, like you talked about in your district, Representative Griffith, in my rural district, we have this same scourge, and I know every community in America is dealing with this scourge. And as law enforcement has noted time and again in their support of maintaining the scheduling, any expiration of that temporary scheduling would have led to a surge of new lethal fentanyl-related substances like nothing we've seen before. This legislation is clearly about maintaining policies that have brought results amidst a deadly epidemic that is ripping through our communities. I appreciate the work that has gone into this important legislation, and I yield back.
Gentleman yields back. Chair thanks the gentleman, and Chair wants to thank this panel of witnesses for appearing before us today for your testimony. The witnesses are now excused. And I want to take the opportunity to welcome our second panel, Chair Virginia Fox and Ranking Member Bobby Scott from the Committee on Education and the Workforce. Dr. Fox, welcome back to the Rules Committee. Always a pleasure to have you back. And Mr. Scott, it's good to see you. And as soon as we get order restored, we're happy to hear your testimony. I think we've got it, so Dr. Fox, whenever you're ready, you may proceed.
Well, thank you, Mr. Chairman, and thanks to the Rules Committee members. Thanks for the opportunity to testify in support of H.J. Res. 45, a Congressional Review Act resolution to nullify the Biden administration's unlawful student loan debt transfer scheme. The Biden administration has decided to rule by executive fiat by, quote, canceling, end quote, as much as $20,000 in student debt for borrowers making up to $125,000 per year or $250,000 per year for married couples. According to the Congressional Budget Office, this scheme could cost taxpayers $315 billion over the next decade. The Biden administration used the national emergency status as justification to advance this action, as well as the now 3-year-long repayment pause. The pandemic is over, yet this legal plan remains. During our markup of the CRA resolution, committee Democrats made 2 wildly inaccurate claims that must be addressed. The first is that the Biden administration's debt transfer scheme isn't a bailout. It's a lifeline for Americans impacted by the pandemic. That's patently false. It's a short-sighted bailout. Loan balances would return to $1.6 trillion in just 5.5 years, even if cancellation now is successful. The second claim made was that the CRA resolution is some sort of cruel measure that will leave borrowers on the hook for exorbitant amounts of interest when loan repayments restart. That's false. Nowhere in the CRA resolution does it mandate retroactive or surprise loan payments. It's entirely prospective, and ultimately the implementation of the CRA resolution is the function of the Department of Education. Additionally, we can see from the CBO score, which doesn't include revenue coming into the government from borrowers being billed for back payments, that this is just a false narrative being pushed by the left to scare people. The bottom line is that the student loan program is failing students and taxpayers, but student loan cancellation doesn't make debt go away. It just transfers it to the American taxpayer. The Biden administration's policies do nothing to solve the root causes of student debt or the rising costs of college. As the institution that holds the power of the purse, Congress has the responsibility to protect the interest of taxpayers. Our CRA resolution is a step towards upholding this responsibility, finding lasting solutions for America's student loan program, and restoring the precept of individual responsibility. I urge the members of the committee to support this resolution. Thank you, and I'm happy to answer your questions.
Thank you, Mr. Chairman and members of the committee. Today I speak in opposition of H.J. Res. 45. There are many challenges that we have in higher education that demand our attention. For example, students and families face a student debt crisis thanks to the rising cost to attend college and chronic state disinvestment in higher education. In fact, between 2008 and 2018, states spent on average 13% less per student after adjusting for inflation. The buying power of the Pell Grant has also fallen dramatically, from covering nearly 80% of the cost of tuition, room, and board at a public 4-year institution in 1975 to now less than 1/3 of that cost. Students continue to grapple with mental health problems and substance abuse challenges. And Republican-sponsored lawsuits against admissions policies at Harvard and the University of North Carolina are threatening diversity at campuses nationwide. But instead of focusing on those challenges, we're spending time on a proposal similar to the one that has already passed in the Default on America Act. Now, let's be clear. This resolution to eliminate modest student debt relief would hurt tens of millions of student borrowers and their families. 43 million student borrowers across the country are eligible for loan relief under the Biden plan, an average of almost 100,000 students per congressional district. Nearly 26 million borrowers in every congressional district have applied for relief, including 16 million borrowers whose applications have already been approved prior to the litigation that has put a temporary halt to the process. That's about a third of those who are eligible, already approved, and that's for about half of the borrowers, that would erase all of their balance due. Now, H.J. Res. 45 seeks to deny all of these borrowers the relief that they were promised and they were counting on. Importantly, the people who would be impacted the most by this resolution are not, quote, wealthy and well-connected, as some from across the aisle have alleged. Under the president's plan, 90% of the relief would go to the borrowers earning less than $75,000 a year. Moreover, H.A. Res. 45 would be impossible to implement, creating chaos for both borrowers and servicers. Even if you don't like the student loan relief, it would be impossible to implement this resolution because you can't pick and choose within a Congressional Review Act which parts of the rule you're overturning. You can't line item a CRA. You have to overturn the whole rule, part of which was the pause in payments. Another was the deferral of interest. There's a lot of questions about how that would get implemented, and the answers are not as easy as some have suggested. First, how do you unpause the October through December payments? Also, there's an interest that accrued during those 4 months that borrowers will now owe if you overturn the rule. It's about $233 per month for every month that they did not make a payment. And what happens to credits that participants in public service loan forgiveness program received? Some used those months and have had their loans totally discharged because they'd gotten to their 10 years using those months. We're talking about public servants like firefighters, teachers, police officers, who were promised that they would receive credit for PSLF program during those months. What do you undischarge those loans? And now are they on the hook for additional payments? H.J. Res. 45 would trigger a wave of delinquencies and defaults for our most vulnerable borrowers. This bill's impact, intended or not, would create chaos, and it is unnecessarily cruel. And by the way, the chaos created by this has been confirmed by the CRS. Lastly, the resolution prevents executive agencies from issuing, quote, substantially the same, unquote, rule of the disapproved rule. In other words, H.J. Res. 45 blocks any future administrative action to support borrowers by pausing payments or interest accrual during future emergencies. Many of our colleagues on the other side have argued that we cannot afford the plan and called it a giveaway. I would point out that at least a dozen members of Congress have received an average of $1 million on PPP loans that were not paid back because they were forgiven. So it's just a matter of priorities. Congressional Republicans were also willing to charge taxpayers $1.9 trillion for a tax package where 80% of the benefits were scheduled to go to the top 1% in corporations. But they're unwilling to invest half that amount to help student borrowers pay for their education. It would be a far better use of our time to focus on proposals that meaningfully support borrowers and make college more affordable for current and future students. Proposals such as the one that Higher Education and Workforce Development Ranking Member Wilson and I introduced earlier this year, the Loan Act, would significantly increase Pell Grants, significantly reduce the interest on student loans, and make college more affordable. The bottom line is that we have a responsibility to strengthen support for those seeking a college degree, not just because everyone should force to get one, but for those who want a college degree, they should have access to that opportunity. Anyone in this country who wants to take advantage of the benefits of a college education, not just the wealthy few, should be able to do so. This proposal does nothing to make higher education more affordable or accessible, so I strongly urge my colleagues to oppose it. Thank you, Mr. Chairman. I yield back.
The Chair thanks both of our witnesses for their testimony. Just, Dr. Fox, just as a practical matter right now, is anyone making payments on their loans, or has everyone just stopped?
Everyone has stopped. And that's been going on since, it's 3 years.
So there's no bearing on whether someone is actually completing their college education versus having dropped out? Everyone is not making payments right now.
Correct.
Well, I agree with both of you that we do need to spend some time tackling the rising cost of college. I would also suggest we need to do something to make colleges accountable for delivering on what they're selling people. And if students aren't able to complete the course of instruction, it's hard to see how they're going to be able to pay back in any scenario.
Mr. Chairman, to your comment about we need to do something about the rising cost of college, all this is going to do is make the colleges go up more and more and more, because they'll just assume in the future that the loans are going to be paid off again, and the students have no incentive not to borrow as much money as they possibly can, whether they need it or don't need it. And we hope to bring forth some legislation in this session of Congress that will do something about that and will make schools accountable. But if we don't stop this illegal payment of loans off, it's just going to make the situation worse, much worse.
And and right now, the college itself doesn't stand to lose anything if
Nothing.
the government pays the loan back, whether the student has graduated or not, whether they got any benefit from the time they spent in college. All of that is just lost in the wash. Is that correct?
Correct. Correct.
So the public health emergency ended. Congress wisely passed a bill, and the president announced the ending of the public health emergency on the 11th of this month. So presumably this extraordinary action is no longer necessary because the public health emergency is over. Is that correct?
Well, presumably, but the administration is not moving forward. Now, they're making an excuse that there is a lawsuit out there with the Supreme Court, but we think that we should take action despite the fact that there's a lawsuit out there. We certainly hope the court's going to rule in our favor, but we don't need to be paying back loans.
Well, I thank you both for bringing the Congressional Review Act to the Rules Committee, and happy to recognize the gentlelady from Pennsylvania.
Thank you so much. Mr. Scott, can you talk a little bit about what would happen if this CRA is overturned and suddenly we have millions of borrowers who are already 8 months in arrears? It sounds as though that's going to create a situation where we could just have a wave of defaults.
Well, if you enact a Congressional Review Act, it's as if the rule was never adopted in the first place. There have been several rules. The one that's the subject of this just covers October to December.
Okay.
So that's what we're talking about. To say that rule never happened means that pause never happened, that interest deferral never happened, and those payments are instantaneously due. So yeah, you're months in arrears because you haven't made those payments. People who have counted those months as they were instructed as part of their public service loan forgiveness, months that they paid and discharged their loan because they had used them to get to the 10 years, now those months don't count. I don't know what you do. Do you unforgive the loan? Who knows? But the reason the pause is still going on, notwithstanding the fact that the emergency is over, is because the litigation is in the Supreme Court. We believe the Supreme Court will say that the rule was legal and that the forgiveness plan was legal. To have people restart paying on a loan that is in the process of being discharged, I think is silly. To gear up, half the people will have their loans totally discharged. And so to have that half paying on loans that the Supreme Court will say they don't owe, and they'll get refunds back on their loan, there's a lot of administration that is unnecessary. As soon as the Supreme Court case is decided, within a few weeks, the payments will begin.
Well, it does just seem like we've got a problem here that by overturning this rule, it'll pitch people into a situation that was even worse than we started with because there's so much uncertainty, because it will put people at risk of default. This is a huge issue for Pennsylvania, where we have a higher percentage of people who have student loans, and on average, they have more student loan debt than most other states. I know over 80,000 people in my district had applied to be eligible for this program, and over 1.2 million in Pennsylvania. So it's a huge concern. It's an area where Congress should be taking action to reduce the cost of college, to up the Pell Grants, to provide better student loan forgiveness criteria, particularly for folks who go into public service positions, and to, not take that action and instead prioritize doing something which is going to cause so much harm is just, once again, a squandered opportunity. I yield back.
Chair thanks the gentlelady. Gentlelady yields back. Chair recognizes the gentleman from Pennsylvania.
Thank you, Mr. Chairman. For the sake of time, I'm going to go ahead and just yield back.
Gentleman yields back. The gentlelady from New Mexico is recognized.
Thank you, Mr. Chair, and thank you, Chairwoman Fox and Ranking Member Scott. I think we need to go back in time, and I always ask my constituents as we talk about the different programs that we have and what they did is remember what it was like, right? Let's remember what it was like when the pandemic hit and our economy was in a free fall. People did not know whether they'd have jobs, whether they'd be able to make rent, or whether they'd be able to make their student debt payments. And we stepped in. We did the right thing. We stepped in, and because we stepped in, the economy is no longer in the same kind of free fall that it was. But the issues around student debt are still very important. And I'm not going to ask again, because I think you highlighted what would happen if the chaos, right, the chaos that would be created if the CRA were passed. And that's something we need to remember. We do not need to create chaos among those who have taken out student debt. And I think that's kind of what you were pointing to. Is that right, Ranking Member Scott?
Exactly. I mean, like I said, there are about an average of about almost 100,000 people in each congressional district that will be eligible for relief. About a third of those had already been approved, ready to go. About half of those, it will discharge the total amount of their loans. And so you've got a lot of people in your district that are counting on this relief that will be very disappointed if this Congressional Review Act resolution passes.
Right. And I think one of the pieces that we don't talk about as often is the PSLF credit, right? The public service workers who received credit for public service between September and December, right? So this is another piece, and these are people there are teachers, there are nurses, there are people we depended on and we continue to depend on. And once again, let's talk about what is the impact on people we care about in our communities. So the other point that strikes me is just like with the Republican tax cuts that led to the ever-increasing debt that we have now, right? Their tax cuts favored the wealthy. If we pass this, it would actually favor the well-off. 90% of the relief would go to borrowers earning below $75,000 a year. If we continued with the relief as set forth, these are for people who are they're teachers, they're people who need the help, right? Less than 75,000 a year. Those are the ones who will benefit if we do this. You know, in New Mexico, it's 60,500 people that are going to benefit from this. Chairwoman Fox, do you know how many people would be denied debt relief in your district?
No, but I do know that only 13% of the people in this country have this debt. 87% do not have debt. And so this is wildly unfair to those people. So if you look at the ranking member said it's about 100,000 per congressional district. Well, then that means 660,000 don't have debt. And so this is totally unfair. Why should 13% of the people in this country, why should 87% of the people in this country pay off the debt of these other people at over $3,500 per person? They either didn't go to college or they went to college and they paid for it themselves. It's totally unfair to transfer the debt from certain people to others. Where are you going to start? Stop doing that. Why is the college debt so significant? How about people who have credit card debt that they had to take out during the pandemic? A lot of people had to take out major credit card debt. So why don't we pay off working people's debt from that?
Well, one of the points, just so you know, 75,900 people in your district would be harmed if we pass this, because they would be denied debt relief. But when we're talking 75,900.
So you're talking about 700,000 people with no debt having to pay the debt of those deadbeats.
I think that's a very good question, Chairwoman Fox. Thinking about how do we deal with wealth, right? And let's look at those 2017 tax cuts. They benefited the most wealthy in our economy. And so that's an example of where we have prioritized, the Republicans, when they were in control, prioritized the most wealthy. And so that did harm the rest of the economy. Ranking Member Scott, do you want to address this issue of who benefits?
Yeah, I didn't hear any equity problems when 80% of the benefits of the Trump tax cut went to the top 1%, not 13%, top 1%. I didn't hear any equity.
That's because, Mr. Scott, those are the people who are paying the taxes. Those other people aren't paying taxes. You got 47% of the people in this country not paying a dime in taxes.
Whatever the cost, whatever the cost of the per person of the student loan relief, it's twice as much to help that top 1%. I didn't hear any equity problems when at least a dozen members of the House of Representatives got an average $1 million PPP loans that were forgiven. I didn't hear any equity problems with that. This is to help those. And the problem occurred because we have disinvested in education. When I was in college, Pell Grant covered 80% of the cost of college. When these people went to college, Pell Grant covers less than a third. And that's because we have been disinvesting. The Pell Grant hasn't kept up with the cost of education. States haven't done their part. They used to pay 2/3 of the cost of a state college. Now, on average, it's less than 1/3. There's colleges in Virginia where the states spend single-digit percentage of the cost of the college. So, you know, we need to not only do this, we need to look prospectively to make college a lot more affordable.
Right, and we want to be in a place where we are assisting our young folks, whether they want to go into vocational, whether they want to go to community college, whether they want to go to university, realize their ambitions. And the issue is, where are you going to invest? Are you going to invest in that 1%? Are you going to invest in those who took at least an average of $1 million in PPP, but don't want to let a little $10,000 or $20,000 go to students who had debt, who were trying? I mean, I've talked to many of these. They've reached out to me. I've done town halls around this issue, and there are people who are doing important work in our communities and need help. They need the help, and this provided that help. Thank you very much, Ranking Member and Chairwoman, and with that, I yield back.
Chair, thanks, the gentlelady. Gentlelady is back. Chair recognizes the gentlelady from Minnesota.
Thank you, Mr. Chair. First of all, I guess, Chairwoman Fox, you know, this, obviously, you know, right now we're in the middle of increasing spending. We're doing all, you know, there's lots going. We're trying to cut it. Republicans are trying to cut it. There's been a lot of spending going on. And I'm just kind of curious, you may have said it, but what is this going to cost? You know, what is this going to add to our debt?
Well, this piece alone is expected to cost $315.6 billion. But that's only one part of the loan scam. What they want to do, and several other programs, we believe would cost up to $1 trillion. So the American people would be on the hook for $1 trillion worth of relief to that 13% of the people who have the loans, okay? And the total right now in outstanding loans is 1.6 trillion. So it would wipe out most of it.
Okay. And there's nothing stopping people from taking out loans today. They're taking them out for summer, they're taking them out for fall semester. They're taking them out today.
I would just about bet you that when we get the information on this fall, we are going to see that loans are up because people are watching what's happening and thinking, I can borrow all I want to. And by the way, in the existing law, a counselor can't tell a student, no, you don't need to borrow all that money. They can borrow a lot of money that they don't need, and if they think somebody else is going to pay it back, some of them will do that.
So in my mind, this does absolutely nothing to address the cost of college, to address the issue of getting students that need assistance to college. This is simply just paying off loans, and what happens in 10 years? Do we do it again? Do we do another $1 trillion every, I mean, because we're going
to be right back here in 5.5 years.
5.5.
5.5 years will be right back here if the trend continues.
So I was being very generous to guest 10, and it is, it confuses me why we are not talking about, I mean, if we want to help people, why are we not talking about the cost, actually dealing with, not just, having legislation that talks about the cost of college, talking about, the structure of those loans, or limiting the cost, limiting the interest, or what. There's so many things that we could be addressing that would actually address the issue, instead of just spending $1 trillion and then in 5 years having to do it all again, when we're not helping those students, those folks with that student loan at all. We're not helping them.
And again, 70% of the people in this country have never gone, they don't have a college degree, and 87 of them, and the others paid back their loans or paid their way, or their parents paid their way. So there's a way to do this. Our colleagues say all the time, oh, if we don't give this money out, people can't go. Well, there are people like I worked my way. Millions of people work their way through school every year, or they save up their money, or their parents work 2 jobs, or it takes 7 years to finish like I did. So this does not stop people from going to college. We have tremendous access, and we have affordable schools. So paying off the debt is not stopping. I mean, not paying off their debt is not going to stop people from going to college.
And I would also argue that maybe people who take out their loans responsibly, and I'm generalizing a little bit, but responsibly, get a degree, get a job, and make a budget.
And most of them pay them back.
All of those people, up until now, who have done that, will now be paying for the 13%. I think we absolutely need to do this. This is one of the things that's it's egregious, because we are just handing out dollars where we should be addressing the issue.
And there's going to be self-attestation on their income. They are not going to have to prove what their income was. There's an income limit, but it's going to be self-attestation.
It just gets better and better, doesn't it? I didn't even realize that. And so it just gets more and more ridiculous that we are just handing out money. So thank you, Chairman Fox, and with that, I yield back.
Chair, thanks the gentlelady. Self-attestation, I guess I didn't realize that. I appreciate you bringing that to the committee's attention.
Well,
Dr. Fox.
Mr. Chairman, that's subject to fraud.
Yeah,
And you've
okay.
got tax,
Yeah, well, believe it when I say
tax
prosecuted.
records.
So
Gentleman
all
from
those
South-
87,000 new IRS agents are going to check that out.
Gentleman from South Carolina is recognized.
Thank you. Appreciate the panelists showing up. You know, this is like this is identical in a way like the penalizing those with good credit reports, paying for those with poor credit reports, paying loans for across this country for students for money we don't have is the stupidest ideas I've ever heard of. As I mentioned earlier, this administration is doing everything they can to bankrupt this country. Chip mentioned the border crisis we have, the cost, and not one word from a Democratic side of the aisle to express outrage. Ms. Fox, one thing that has not been talked about is the message that's being sent should this pass, should the president get his way. What does this tell to every college all over this country about rates? You are a professor. Does this not just give them the green light to charge whatever they want to charge? Because they're not paying the bill.
Absolutely, because they have absolutely no accountability. They can charge as much as they want, and we know that increase in cost in colleges has been higher than the rate of inflation for the past, I can't remember exactly how many years. It's close to 20, though. It keeps going up and up and up. It's even higher than the rate of inflation for medical costs. I mean, rate of inflation and medical costs.
And what message does this send to those who who want to learn a trade, do not want to go to college? To the plumber, to the electrician, to the framing contractor, to the brick mason? What message does this send?
It's that you're going to pay for other people who want to go to college.
Just getting them on the public dole.
Just get on the bill.
further. Do you
Yeah,
realize,
I call this welfare for wealthy people because the majority of the loans that are going to be paid off are for people who went to graduate school.
okay, well, it's insanity at its height. It really is. It's insane what's happening and the things that are being proposed. I don't want to belabor this. Thank y'all for appearing. I yield back.
Chair, thanks the gentleman. Chair recognizes the gentleman from Texas.
I thank my colleague from Texas. Representative Scott, you suggested earlier that students are suffering from the rising costs. In what universe will this do anything to lower the cost of education?
It will improve access because they will be able to pay. Well, they're in the mess because we haven't kept up with access. Like I said, when
But how does it lower the cost of tuition? How does it lower the cost of education?
It doesn't lower the cost of education.
It just
the
forgives a
college-
loan.
That's right. Because,
Right, which doesn't lower the cost of education.
And you want to note why the cost to the student is so much. When in the 1970s, the Pell Grant covered 80% of the cost of going to college, and now it's less than a third, and people are still trying to go to college.
Well, stated differently, why is tuition so much higher today than it used to be? On a relative basis to all other goods and services, the cost of education has gone up exponentially relative to the cost of all other goods and services with the exception of health care. Why is that?
I don't know why, but it is. And you're telling students.
But there are economic principles at stake. Why is the cost of education exponentially higher today than virtually every other good and service except for health care?
Well, you're going to have to ask the college administrators why the cost of college is so high, but the problem that students have is they got to pay it.
Chairwoman Fox, do you have an answer to why you believe the cost of education is so much higher, exponentially higher than all other goods and services?
Well, I think it's because the federal government subsidizes education. Let me give you an example. The more federal aid and generous loan subsidies that we give out, the higher go the prices of tuition. For example, for every $1 increase in student loan subsidies, colleges increase their tuition 60 cents. So we know that the more money you put out there, the more the colleges and universities are going to charge. Increased availability of graduate loans led institutions to increase their cost of attendance dollar for dollar, with no evidence that such loans led to increases in accessibility and enrollment of disadvantaged students. Colleges reduced their own grant aid by as much as 83 cents for every dollar students receive in taxpayer student aid.
Let me ask you another question, Chairwoman Fox. I heard earlier that this is similar to a PPP loan. Now, I take issue with that characterization because whatever one thinks of the CARES Act, I have massive problems with the CARES Act and its $2 trillion of inflation causing spending and paying people not to work and the absolute absurdity of the way it was structured. But let's put that aside for now. You have a CARES Act that included a PPP, which included provisions in it which was designed, somewhat not perfectly, but designed to do what?
To keep people working, to provide goods and services to American people when their government was shutting them down.
So would you agree with me that that is more analogous to a takings under our constitutional jurisprudence and history than it is some sort of policy choice about what you're doing with respect to loan forgiveness or tax policy, right? You have the power of the federal government, the power of state government, the power of local government, shutting down people's livelihoods, entirely shutting them down.
Correct.
So you're a restaurant in Richmond, Virginia, Austin, Texas, New Mexico, Pennsylvania, shut down because Anthony Fauci waved his magic wand and said, must shut down, must wear masks, must do all this stuff because I'm boy genius. Right. And all these people out there working who built up a livelihood, had a business, built it up from scratch, passed it down to their kids. They lose their entire livelihood. The same as if you took a highway and bulldozed it.
Exactly.
Like a taking. So a PPP loan, it was a loan, right, that would be forgiven if certain criteria were met. And what were those criteria to the best of the chairwoman's recollection?
Well, that they kept everybody employed and they stayed open and they did the things that were out there in the loan. Now, in the student loan issue, we are giving to the people who took out this $1 trillion in loans, and we're transferring the debt to somebody else. The people who owe this money willingly took it out to make more money by going to college. Not the same as what the federal government did, as you said, in shutting people down. It was a taking of their business.
So, question there. My wife was the daughter of a single mom, had very little resources. Her mom worked multiple jobs in order to get her through school and to get her to be able to go to the place of going to college. Because her mom didn't go to college, and she wanted that for her daughter as a single mom. And my wife performed very well in school and had the choice to go to schools such as Duke, which cost a lot of money, or some Ivy League options she had that cost a whole lot of money. She chose to go to Texas A&M University. Now, I think that was a good choice for a variety of other reasons that I won't get into at the moment. But she decided to go to Texas A&M mostly because it was financially more viable and she would take on less debt. Now, my wife, nevertheless, took on about $50-something thousand of debt to get through her undergraduate education on top of having worked 2 jobs through school in order to pay her way through school. She then matriculated and then went to the University of Texas, where we met at law school. She took out student loans at the University of Texas. So at the time of our marriage, she had over $100,000 of loans. Now, she is at the tail end of still paying for those loans. After 20 years, our 20-year law school reunion was last month. So 20 years later, she has sacrificed, drove a 2000 Corolla with no options for years after years after years, drove, a crappy car while watching all these other people riding around in their fancy car, making tough choices, tough choices about where to live, what to do with her kids, making sacrifices so her kids could go to the school that she thought was appropriate, literally sacrificing. I've sat there with her in tears, dealing with what we have to deal with in a family budget. And she did that. She worked hard. Her brother did that. Now, none of that's getting paid off because she already paid her loans off. I took out some loans. I had to pay my loans off. So my question is, for the 87% of Americans who don't have the student loans in question, for the person who paid off their loans like my wife, for the plumber in San Marcos, Texas, busting his rear end right now and started a business from scratch, didn't take out a loan, what do we tell him? What do we tell my wife? When the federal government comes in and writes a check for $500 billion to say, here's, in the words of my colleague on the other side of the aisle, just a little $10,000 for you, because we're going to write a check with money we don't have, with printed money. What do we tell the person who worked their whole life to pay off those loans? Chairwoman Fox.
Well, some people might say you're a sucker for having done it. That's what they'd say. But you're getting nothing. You're getting nothing. You played by the rules, you did it the right way, and you're getting nothing. Too bad.
Chairman Scott, what would you say to my wife who played
You know,
by the rules?
I would say the same thing you would say to somebody that didn't pay off a PPP loan, $1 million. You got people, members of the House, got $1 million to help their businesses.
That is a deft deflection. Why don't you take that up with the members of the House who didn't pay the loans that you have an issue with? What would you say to my wife?
Say the same thing to the,
What do you say to my wife?
To the 80%, to the people who didn't, to the 99% that didn't get benefits.
What do you say to my wife who spent her whole life paying her loan off? Too bad? Too bad? You didn't get the $10,000 check?
Well, I'd say the same thing. It's not perfectly equitable. You're absolutely right.
Perfectly equitable. It's
Okay.
literally a check to 13% of Americans so that some people can pat themselves on the back in the false name of compassion while you're destroying the work ethic of the country. I mean, how is it remotely equitable to take money and to go pay off a loan?
You have no problem with equity with a tax benefit twice as big going to the top 1% in corporations. No problem with equity at all. No problem with the $1 million PPP
Wait, hold on.
loans.
Make that statement
And
again.
What do you say to?
No, hold on. Make that statement again.
What did you say to the 99% of the people didn't get PPP loans?
The people who got the PPP loans were people who applied for loans to keep businesses afloat, which was the legislation that my Democratic colleagues helped jam through as a part of the CARES Act in a panic over COVID. I wasn't the one that was chomping at the bit to jam the CARES Act through.
I didn't get a PPP loan. I didn't get $1 million PPP loan.
Right, but everybody in this freaking building voted to jam that through.
That's right.
Right. And so the PPP loans existed. Why? To try to keep businesses afloat that were getting shut down by the power of government.
And we had to help people. We had unemployment compensation.
Right, but we were trying to keep businesses afloat. And yes, it was abused. Shocker of all shocks.
Okay.
A government program of billions of dollars got abused by some people.
Everybody's not going to benefit from this proposal. You're right.
But how is it that we can just choose, hey, here's a check?
How do you choose on a PPP loan? Everybody didn't get a $1 million PPP loan.
Because you create a policy where you allow people to apply who have businesses who are shut down. That's how. Now, again, not a huge proponent of the entire CARES Act structure.
Right.
We tried to fix PPP
Well,
on the
you don't
back
have any
end.
problem with somebody getting a $1 million PPP loan and not paying it back?
No, I got a huge problem with that. That's why I don't like government programs in the first place. I hate them.
And you got a problem with somebody trying to pay off their student debt?
And the chairman, the ranking member, is making a great case for why we shouldn't have all these programs in the first place that get abused by people through the abuse of government power.
We wouldn't be in the situation if the programs had been as they had been originally planned.
Wait, more government subsidies for more government programs.
Covered 80% of the benefit of going to a state college.
Does Chairwoman Fox have it? You said you had something you wanted to add to that?
Now it's the third. And you expect people to be going to college. Now, some of us think going to college is a good thing. and ought to be available to everybody.
Well, actually, if
I know that's controversial around here.
I've got a thought on that in a second, but would the chairwoman have a thought on this question?
Well, yes, I do. I have two thoughts. Number one, PP loans were a part of legislation,
Right.
as you have pointed out.
Right.
This loan forgiveness has never been voted on by
Of course not.
Congress. This is illegal. The power of the purse belongs to Congress. It does not belong to the president. So that is, the other thing I would say is when there's an argument about Pell Grants, I read the Constitution, and nowhere in the Constitution do I read you're guaranteed a certain amount of money to go to college. In fact, the word education isn't in there at all. But what the Declaration of Independence tells us is we're guaranteed life, liberty, and the pursuit of happiness.
Amen.
We're not to have it dumped in our lap.
To the gentlelady's point, I'm going to ask the gentlelady if she remembers this quote. People think the President of the United States has the power for debt forgiveness. He does not. He can postpone. He can delay, but he does not have that power. That has to be an act of Congress, end quote. Do you remember who said that?
Nancy Pelosi.
Speaker Pelosi. Do you know what else she said? Quote, suppose your child just decided they, at this time, do not want to go to college, but you're paying taxes to forgive somebody else's obligations. She continued, you may not be happy about that, end quote. Wow. Speaker Pelosi, all of a sudden, a extreme MAGA Republican. How about Representative Pappas, who said, quote, but this announcement by President Biden is no way to make policy and sidesteps Congress and our oversight and fiscal responsibilities. He continued, quote, any plan to address student debt should go through the legislative process, end quote. Another extreme MAGA Republican, or is that a Democrat, Representative Pappas?
That's a Democrat.
And Representative Golden from Maine, quote, this decision by the president is out of touch with what the majority of the American people want from the White House, which is leadership to address the immediate challenges the country is facing. The president should be taking action to reduce inflationary pressures. With this move, he potentially makes them worse. It is out of step with the needs and values of working class Americans, end quote. Again, extreme MAGA Republican, Representative Golden from Maine. Does that sound right? Do you remember these quotes,
yes,
Chairwoman? You know, one other point here is this question about that everyone should be able to get a college education if they want to. Well, first of all, does the gentlelady agree that you may join ROTC or join the military? I understand they're having some recruiting problems for reasons we could talk about in another hearing, about another topic, about the decisions being made by the brass at the Pentagon. But you could join the military or ROTC and get part or all of your college paid for. Would it surprise the gentlelady that according to a poll conducted by Mission Roll Call, 6,202 veterans, 76% said they disapprove of the push to forgive student loan debt for those who haven't served in the military.
Would
Would that
the
surprise the gentlelady?
Gentlemen yield quickly. This is
gotta
a
vote.
time management question.
Yes.
I'm not trying to cut anybody off, but if we're going to finish our last two questioners so you can be dismissed. Otherwise, we'll have to bring the witnesses back.
I will wind up in 2 minutes.
All right.
Well, can we go vote?
We're going to have to recess anyway? You got to recess now, then. Oh, well, then we're going to have to recess now, and then we come back and we can
Okay.
resume.
All right.
I would, committee stands in recess. I'd remind our witnesses, if you could, there's 3 votes. You cast your third vote. If you come back, we'll start as soon as you get back here. Same advice, obviously, the members of the committee. With that, we're in recess. You both have been doing the Lord's work. Now, committee will reconvene to continue consideration of H.R. 467, S.J. Res. 11, and H.J. Res. 45. When we recessed, Mr. Roy was questioning, so the gentleman from Texas is recognized to resume his questions.
I think, Chairman, I know we're on time here, and I said I'd be a couple more minutes. I'll leave it at that. I wanted to just close with what I was saying to the chairwoman about the quotes from the military guys who've been interviewed and said, well, why are we doing this? When I went and sacrificed and did all that I was going to do to put my life on the line for this country and get those benefits. Here's a quote from one Marine Corps veteran in an op-ed from Fox, Cole Lyle, quote, I joined the Marine Corps 2 weeks out of high school, deployed to Afghanistan, earned my degree using the GI Bill. I know firsthand the sacrifice service members made to earn that benefit. They all made a choice. In most cases, joining the military meant receiving the GI Bill and the chance to go to school for little to no cost. They earned that opportunity. I assume the chairwoman agrees, and I'll leave it at this, agrees that that is another reason why this is a massive problem, in addition to the final point that were we to actually be successful with this CRA and the president signed it into law, or were we to pass the debt ceiling bill that we've already passed and signed into law, ending this program, that we would save immediately almost $500 billion in 2023 deficit spending. Is that right?
That is correct, and what's going to happen again is if we are not able to stop these programs, the increase in the debt and inflation are going to continue to go up. This is a very inflationary measure in addition to adding to the debt, which we know adds to inflation.
Well, I think the gentlelady, I just want to state again, we would immediately save almost $500 billion in 2023 deficit if we were to pass this CRA and or if we were to pass the debt ceiling bill that Republicans responsibly passed a few weeks ago and the president has ignored. I yield back.
If I could make one more comment. I appreciate your bringing up the GI Bill, that anybody who joins the military can get a free education. But you know, this business of education being unattainable in this country is a straw dog, because most anybody in this country right now can get an education without going into debt. Many are like your wife. They face that decision whether to go to a very expensive school or one that's affordable.
More affordable, right.
Or right now, most states are offering the opportunity to get a free AA degree, AAS degree while still in high school, and many students are doing that, and then others can work their way through college. But access is not an issue in this country. Who pays for the college education can be an issue, but a person can get through college without any debt whatsoever.
I also appreciate that from the gentlelady and would also posit that anybody graduating high school right now, you're going to do a lot better off if you go get your welding certificate, your plumbing certificate, start a business, and don't go to school and go get a degree in gender studies. I yield back.
Gentlelady from Indiana is recognized for any questions she cares to pose to the panel.
Thank you, Mr. Chairman, and thank you for testifying before us today, Madam Chair and Ranking Member Scott. I'm a parent of a freshman college student with 2 more teens preparing to attend college. I want to express my support of H.J. Res. 45 and urge the committee to pass the bill. I remember as a young adult considering what type of career I might decide and what college degree or what was the best path for me. I've gone through similar conversations with my teens. However, not everybody chooses to go to college. Some choose different career paths that don't require a college degree, and therefore they make a decision to not incur college loans. I'm very concerned that this student loan forgiveness is being extended to people who are certainly capable of paying off their loans independently. It seems to me like it's a giveaway to the rich. I'm greatly concerned with allowing President Biden's intent to spend $315 billion of taxpayer money without any kind of congressional oversight. Over 60% of my constituents chose not to attain a college degree. Yet if this student loan forgiveness and the proposed income-driven repayment plan are not halted, $3,527 from each of my constituents will be used to pay for someone else's financial decisions. A few things I'd like to note. We've discussed about the cost of college going up. I was a witness to that firsthand. I got my master's degree and I sought a student loan. And when I filled out the paperwork, the question was asked, how much does it cost? And the loan came back exactly for that amount. So as we've heard Dr. Fox, if the government is going to pay the check for any amount for every student loan bailout, what will that do to the cost of tuition?
Well, we've talked about this a little bit before. For every dollar increase that the taxpayers give at the federal level, tuition goes up 60 cents. And so all we're doing is encouraging colleges and universities to increase their cost with no accountability for whether the students are in a program that's going to give them a degree, that's going to allow them to pay back their loans. So the colleges and universities have no accountability. They can just continue to raise their costs, and they will, because they've shown that they would in the past.
Thank you. And a few other things to note, not just people that have chosen not to seek a college degree because of cost or other factors, but I paid off my student loan. I worked very hard to do that. We have saved into our children's 529 accounts since they were born. And it wasn't a factor of having a lot of resources to do that. In fact, when I first got married to my husband, he was a law student, and I was the only person making an income. I was making about $27,000 a year as a family case manager for child services. I was pregnant with our first daughter. We saved as much money as we possibly could so that I could take a full 12 weeks of maternity leave. And when I went back to work as the only breadwinner for our family, we had $100 in the bank. We planned it precisely to get us through that. So we saved from the time our kids were born into 529 accounts, and we sacrificed, and that's okay. We're trying to make as responsible of financial decisions as we can. So again, I want to reiterate, this student loan bailout seems to me to be a giveaway to the rich at the expense of those who've made a different choice and find themselves in different circumstances. What does this say to all the Americans who made an informed, different choice to not seek college?
Well, as we said earlier, this says, silly you for having played by the rules, planned carefully, sacrificed for yourself and your family, and paid back your loans.
Yeah. Dr. Fox, I just want to ask, we've heard, and you've touched on this a little bit, but if you could please respond to criticism that we've been hearing from our Democrat colleagues who claim Republicans are somehow being hypocritical because of their support for the PPE loan program that was put in place in response to a government taking following COVID, but not supporting blanket student loan bailouts like the president is proposing. Is this an apples-to-apples comparison?
This is not an apples-to-apples comparison. Number one, the Congress of the United States voted, or members of the Congress voted for the PPP loans. Those loans were given out to help people keep their businesses open, to provide jobs for people, and also to provide necessary goods and services to the American people. So this is not the same at all as people who willingly took out debt to better themselves, to help themselves make more money. That it's a totally different situation. And Congress voted for that. On this, Congress has not voted. This is a unilateral decision by the president, who I believe does not have the right to do that, because only the Congress can appropriate money. And the president is attempting to appropriate taxpayer dollars, I think, illegally.
Thank you, Dr. Fox. I appreciate you leading this charge. Appreciate it very much. I yield back, Mr. Chairman.
Thank you very much. Gentleman from New York is recognized for any questions he may wish to pose to the panel.
Thank you so much, Mr. Chairman. And Dr. Fox, I mean, clearly we have the Biden administration trying to push forward an irresponsible measure that they claim is a solution to a government-created problem, as you point out. I'd like to just pose to you, instead of using tax dollars for a big bailout for those that chose to take loans versus those that didn't, where should we instead be focused when it comes to reducing the cost of higher education? I mean, it strikes me that we're out there up against the big educational industrial complex that keeps running up the score, running up the price, and the only solution that we've heard so far is more free stuff. So I'm eager to get your take on this.
Well, one of the ways we'd like to do this, and we will be bringing forth later this year reauthorization of the Higher Ed Act. And one of the plans that we have is to have colleges and universities have skin in the game so that if students graduate and they don't pay back their loans, or even if they don't graduate, if they attend college and they take out loans and they don't pay them back, then we think it's up to the colleges and universities to have some skin in the game on this issue. And to go back to what I said earlier, the more we ask the taxpayers to put in, the higher is going to be the cost of attending colleges and universities. We want to see that increase stop at some point.
Well, thank you very much, Dr. Fox. I mean, and I've toured some of the great educational institutions in my district. There are fabulous options for a low-cost education, especially as we're already investing so much of our state and federal dollars from the taxpayers into so many of our state educational institutions. In its opposition to this resolution, the Biden administration stated that our actions here are undercutting the economic recovery of the nation. And as I'm sure we all hear from businesses, farms, and factories all over the country, we have a labor shortage here. And I'm not talking about minimum wage jobs and service jobs. We're seeing good paying jobs that require less education than a 4-year college degree, staying vacant, staying on the books. And it's having an impact on our long-term economic health, our ability to produce and to innovate. And it's having a long-term impact on our communities. This labor shortage and the rush to pursue expensive degrees without true return on investment, this is what is and will be undercutting our economic recovery and continued economic health if we don't move away from the paradigm that every single individual needs to go to college for 4 years and get a liberal arts degree. I support this resolution. Thank you, Dr. Fox and the ranking member, for being here, and I yield back, Mr. Chairman.
Thank you very much, and I want to thank our panel for appearing for us today and certainly for coming back after votes. It's much appreciated. You're excused, and have a good evening.
Thank you, sir.
Thank you. Okay, after, let's see, we now, I'd like to invite Representative Green to the table as soon as our witnesses leave.
Bobby said if I had mentioned short-term Pell, I should have mentioned, then it would have messed things up because he would have been in agreement.
The gentlelady from Georgia is recognized to present her amendment.
Thank you very much, Mr. Chairman. I come before you tonight to introduce an amendment to H.R. 467, the Halt Fentanyl Act. My amendment will reads, notwithstanding any other provision of law, any person who knowingly or intentionally imports fentanyl or any fentanyl-related substance across the southern border shall be punished by death. And I want to talk to you about why this is such an important amendment. Fentanyl, of course, we all know, is the #1 killer of Americans between the ages of 18 and 45. And it's hard to comprehend that our young people are dying today from a drug that is coming from China into Mexico and being trafficked across our southern border by the cartels. Fentanyl kills approximately 300 Americans today. In 2023 alone, CBP has seized over 17,000 pounds of fentanyl coming across the southwest border. This is enough fentanyl to kill over 3.8 billion people. That's how dangerous this drug is. Fentanyl poisoning deaths among teens accounted for 77% of adolescent overdose deaths in 2021. Fentanyl and fentanyl-related substances can be 50 to 100 times more potent than morphine. We need to talk about people that are willing to cross our border. Of course, there's many reasons coming across, but they should never, ever bring a deadly poison into our country that murders Americans. In my state alone, fentanyl-involved deaths have increased in Georgia by over 230%. In counties throughout my district, the Georgia's 14th district, from 2019 to 2022, fentanyl-involved deaths have increased by over 350%. There's examples all over the country that are similar to the ones in my district. A 16-year-old girl in Whitfield County who had never taken any illegal drugs or substances in her life took a Xanax she thought was going to help her anxiety, and within 5 minutes, she was dead because it was laced with fentanyl. We also had many overdoses throughout the months and years that the Biden administration has been in charge, and the fact that fentanyl is murdering so many people in Northwest Georgia is shocking. In November 2020, another horrifying story that happens too much. Corporal Christopher Jackson Dye, a Walker County Sheriff deputy, died after being exposed to fentanyl during an arrest. These are stories that we hear too often. But I'd like to talk with you all also, just to let you know, that there are 41 capital offenses that are punishable by death. Many of these capital offenses involve murder, all types of murder. Murder related to smuggling of aliens, that is punishable by death. Murder committed during a drug-related drive-by shooting, that is punishable by death. Murder committed by the use of a firearm during a crime of violence or drug trafficking crime, that is punishable by death. Genocide is punishable by death. And one could argue, is fentanyl a type of genocide in America today? Other examples of murder that result in the death penalty. Murder for hire involving the use of interstate commerce facilities. Murder involved in racketeering offense. Willful wrecking of a train resulting in death. Bank robbery-related murder or kidnapping. Murder related to a carjacking. Murder related to rape or child molestation. Murder related to sexual exploitation of children. Murder committed during an offense against maritime navigation. Murder committed during an offense against a maritime fixed platform. Terrorist murder of a U.S. national in another country. Murder by the use of a weapon of mass destruction. And I think it is easily arguable that fentanyl is definitely a weapon of mass destruction. There's even death resulting from aircraft hijacking, of course, is punishable by death. So I think it is very, this fits the Halt Fentanyl Act, my amendment, to punish anyone who knowingly and intentionally imports fentanyl into our country that is responsible for murdering over 300 Americans every single day shall be punished by death. Thank you. I yield back.
Thank the gentlelady for her testimony. Chair has no questions. Dr. Burgess?
Thank you for bringing this to our attention. I have no questions.
The gentlelady from Pennsylvania.
Thank you. I don't have any questions, but I would like to suggest that this amendment, which applies an automatic death sentence to anyone who imports any amount of fentanyl-type drugs, so long as it comes across the southern border, is not a serious or rational response to a very serious problem. I mean, we've had, at the port in Philadelphia a couple years ago, we had 110 pounds of fentanyl seized, and it came through the port of Philadelphia. So the fact that there would be this bizarre distinction between the southern border and the other ports where 90% of the fentanyl is coming in, doesn't make any sense. On the off chance this is supposed to be a serious amendment and not just clickbait for social media or campaign donations, I would offer the following points for consideration.
Nothing is for clickbait
It's
or
my time.
campaign donation.
First of all, the amendment's unconstitutional. The Supreme Court has been clear that the death penalty is a violation of the Eighth Amendment in circumstances where death was not the immediate result of the violation in question. This law contains no such limitations as to seriousness, and what the court said there, and I think it's instructive, is that when the law punishes by death, it risks its own sudden descent into brutality, transgressing the constitutional commitment to decency and restraint. Second, it would have the absurd result that you've got a mandatory death penalty for someone who brings a pill with fentanyl across the southern border, but not for someone who imports hundreds of pounds of fentanyl anywhere else in the country. Third, it imposes a mandatory minimum sentence of death. We've had a lot of conversations, and granted, it was before you came to testify today. We've had a lot of conversations here today about the validity or the use of mandatory minimum sentences, but this would be the first and only mandatory minimum sentence in U.S. history. And none of the other offenses that you cited have a minimum sentence of death regardless of the circumstances. It's always a maximum. So I obviously can't support this amendment, and I yield back.
The gentleman from Pennsylvania is recognized.
Thanks, Mr. Chairman. Would you like to respond to any of that?
Yes, absolutely, I would. First of all, this is not for campaign donations or clickbait like what you said would be for campaign donations and clickbait, and I find that offensive. Secondly, the amendment reads, any person who knowingly or intentionally imports fentanyl. And I would think that you would care about 300 Americans dying every single day, especially young people. But I do agree with you, it shouldn't be just across the southern border. It should be anywhere across our border. And it should be punishable, again, by death. And as far as the death penalty being constitutional, there's 41 capital offenses that are punishable by death. So clearly, murder is punishable by death, and murdering 300 Americans every single day, knowingly and willfully, should be punished by death. Thank you.
I yield back.
Gentlelady from New Mexico is recognized.
Thank you very much. And I think that the key distinction, as pointed out in the Supreme Court opinions, was whether the importation is tied to the murder. And it's this time that is key. And I think that that's what you were pointing out. Do you want to add anything else to that?
No, just that is the point, is that there are no limitations on what's been proposed here, other than it has to be an importation across the southern border. No limitations as to harm caused, personal use, anything else. Obviously, none of us here want to encourage the importation of fentanyl, but also we don't want to encourage the descent of our laws into brutality and transgressing the constitutional commitment to decency and restraint.
Right, and as I point out, that none of those crimes that you listed have a mandatory minimum. And I really want to go back on the record and point out that under the Biden administration, we have been steadfast at attacking fentanyl. Nobody, no Democrat on this committee has said that we are in any way, supportive of any kind of fentanyl. We indeed are insistent that the problem with this bill is it doesn't go far enough. It doesn't go far enough. Our communities want us to do more with regards to enforcement. They want us to do more with regards to treatment. And that's what we need to do, is we need to do more. This bill doesn't do enough. So with that, I yield back. Thank you very much, Mr. Chairman.
Gentlelady from Minnesota is recognized.
Thank you, Mr. Chair. And would you like to respond to the last comments?
Yes, thank you very much. I think if Democrats really cared about stopping fentanyl and cared at all about Americans being murdered, 300 every single day, due to Biden administration failed border policies and the national security crisis that the Biden administration has created, you all would have voted for H.R. 1, our very strong bill, and our border security package, increasing American energy, but also protecting America's border, helps America's national security. And our border security package brings back Trump's administration border policies, and Joe Biden, through executive orders, wrecked all of those. And that's why we have over 300 Americans dying every single day. You talk about what is humane and decent in treating people. That would be protecting our southern border and stopping people from knowingly and intentionally importing fentanyl that, again, is a poison that comes from China. If Joe Biden cared about saving American lives, he would be strict on China and the amount of fentanyl that they're bringing in and just handing over, selling to the Mexican cartels. If Joe Biden cared about saving American lives, 300 American lives every single day, every day. It's like a bomb going off and 300 Americans dying. Then Joe Biden would do something about the Mexican cartels who are basically running 5 out of 9 border sectors across our southern border. If Joe Biden cared at all about these 300 Americans, who, by the way, most of them are under the age of 45, then Joe Biden would absolutely be working with our speaker in this debt ceiling negotiation and making our border security package part of that negotiation. But clearly Joe Biden doesn't care at all, and the Democrats don't care at all about border security or 300 people that die every single day. Thank you.
Thank you, and thank you for being here. I yield back.
Gentleman from Kentucky is recognized.
Thank you, Mr. Chairman. You know, we all represent roughly 750,000 people, and I think we should take everybody seriously who comes before us and not question their intents or their motives or their seriousness. And that's all I had to say, and I'll yield back.
Gentleman from South Carolina is recognized. Gentleman from New York is recognized. Oh, we thank you for coming, and you're excused.
Thank you.
Okay, thank you. Is there anyone else seeking to testify on H.R. 467, S.J. Res 11, or House J. Res 45? Seeing none, this closes the hearing portion. The chair will be in receipt of a motion from the gentleman from Texas, Dr. Burgess.
Mr. Chairman, I move the committee grant H.R. 467, the Halt Fentanyl Act, a structured rule. The rule waives all points of order against consideration of the bill. The rule provides 1 hour of general debate, equally divided and controlled by the chair and ranking minority member of the Committee on Energy and Commerce or their respective designees. The rule provides that the amendment in the nature of a substitute recommended by the Committee on Energy and Commerce, now printed in the bill, shall be considered as adopted, and the bill, as amended, shall be considered as read. The rule waives all points of order against provisions in the bill as amended. The rule further makes in order only those amendments printed in the Rules Committee report. Each such amendment may be offered only in the order printed in the report and may be offered only by the member designated in the report, shall be considered as read, shall be debatable by the time specified in the report, equally divided and controlled by the proponent and an opponent, and shall not be subject to amendment, shall not be subject to a demand for division of the question in the House or in the Committee of the Whole. All points of order against the amendments are waived. The rule provides 1 motion to recommit. The rule further provides for consideration of S.J. Res 11, providing for the congressional disapproval under Chapter 8, Title 5 of the United States Code of the rules submitted by the Environmental Protection Agency relating to the control of air pollution from new motor vehicles, heavy-duty engine, and vehicle standards under a closed rule. The rule waives all points of order against consideration of the joint resolution. The rule provides that the joint resolution shall be considered as read. The rule waives all points of order against provisions in the joint resolution. The rule provides for 1 hour of general debate, equally divided and controlled by the chair and ranking minority member of the Committee on Energy and Commerce or their respective designees. The rule provides 1 motion to recommit. The rule further provides for consideration of H.J. Res 45, providing for congressional disapproval under Chapter 8, Title 5 of the United States Code of the rules submitted by the Department of Health, by the Department of Education, relating to waivers and modifications of federal student loans under a closed rule. The rule waives all points of order against consideration of the joint resolution. The rule provides that the joint resolution shall be considered as read. The rule waives all points of order against provisions in the joint resolution. The rule provides 1 hour of general debate, equally divided and controlled by the chair and ranking minority member of the Committee on Education and Workforce or their respective designees. Finally, the rule provides one motion to recommit.
Thank you very much. You've now heard the motion. Is there any discussion or amendment to the rule?
Yes, sir.
Gentlelady from Pennsylvania is recognized.
First, can I have unanimous consent to enter a statement from Representative Tony Cardenas into the record?
Without objection.
Okay. I'd ask unanimous consent to enter the statement in support of his amendment requiring the DEA to conduct and publish scientific and medical evaluations of fentanyl-related substances on a public website.
Without objection.
Mr. Chairman, I also have an amendment to the rule.
The gentlelady is recognized.
I move the committee make in order amendment number 59 to H.R. 467 offered by Representative Crockett, which exempts the possession, sale, or purchase of fentanyl drug testing equipment from constituting as drug paraphernalia. Like probably most people in this room and around the country, I too have had a relative who's been impacted by opioid use and fentanyl use. That young relative had to be revived multiple times before he was able to get into treatment. And today, he serves as a counselor to others who've been similarly impacted. The use of drug testing equipment is critical to reducing harm of others who've been impacted by this, and it's going to be one of the things that helps save more lives. So I would move that amendment.
Is there any further discussion on the amendment? Hearing none, the question's on the amendment. All those in favor signify by saying aye.
Aye.
Those opposed say no. No. Opinion of the chair, the noes have it.
I'd request a recorded vote.
Recorded vote has been requested. The clerk will call the roll.
Mr. Burgess.
Burgess votes no.
Mr. Burgess, no. Mr. Rushenthaler. Mr. Rushenthaler, no. Mrs. Fishbach. Mrs. Fishbach, no. Mr. Massey. Mr. Massey, no. Mr. Norman. Mr. Norman, no. Mr. Roy. Mr. Roy, no. Mrs. Houchin. Mrs. Houchin, no. Mr. Langworthy.
No.
Mr. Langworthy, no. Mr. McGovern. Ms. Scanlon.
Yes.
Ms. Scanlon, yes. Mr. Neguse.
Yes.
Mr. Neguse, yes. Ms. Ledger Fernandez. Yes. Ms. Ledger Fernandez, yes. Mr. Chairman.
No.
Mr. Chairman, no.
Clerk will report the total.
3 yeas, 9 nays.
Noes have it. The amendment's not agreed to. Are there any further amendments in discussion? Gentlelady from New Mexico is recognized.
Representative Papas, which strikes the text of the bill and inserts this Save Americans from the Fentanyl Emergency Act. We discussed a lot of this earlier this evening, where the SAFE Act is the full Biden administration proposal to combat this crisis. We need a comprehensive approach to end this crisis, and this amendment would set us on this path. I would note that earlier, as we were discussing this, it pointed out, I believe it was Chair Griffin, pointed out that this the present bill makes the current situation permanent. But that's sort of like just doing the status quo, when I know our communities want us to do so much more, from dealing with the research necessary to identify when fentanyl is in a subject, to more enforcement as well as treatment. So I would hope that my colleagues would support this and let our colleagues on the floor of the House vote on this bipartisan amendment.
Is there any further discussion on the amendment? Seeing none, the question is on the amendment. All those in favor signify by saying aye.
Aye.
Those opposed say no. No. The opinion of the chair, the noes have it. The amendment's not agreed to.
Mr. Chairman, a recorded vote, please.
Recorded vote's been requested. The clerk will call the roll.
Mr. Burgess. Mr. Burgess, no. Mr. Rushenthaler. Mr. Rushenthaler, no. Mrs. Fishbach. Mrs. Fishbach, no. Mr. Massey. Mr. Massey, no. Mr. Norman. Mr. Norman, no. Mr. Roy. Mr. Roy, no. Mrs. Houchin. Mrs. Houchin, no. Mr. Langworthy. Mr. Langworthy, no. Mr. McGovern. Mrs. Scanlon. Ms. Scanlon, yes. Mr. Neguse.
Yes.
Mr. Neguse, yes. Ms. Ledger Fernandez?
Yes.
Ms. Ledger Fernandez, yes. Mr. Chairman?
No.
Mr. Chairman, no.
Clerk will report the total.
3 yeas, 9 nays.
Amendment's not agreed to. Is there any further discussion or amendment?
Mr. Chairman,
Gentlelady from New Mexico is recognized.
thank you. I have an amendment to the rule. I move the committee make an order amendment number 66 to H.R. 467, offered by Representative Peterson, which authorizes the Secretary of HHS to submit a scientific determination to the Attorney General to reschedule or remove a fentanyl-related substance.
Is there any further discussion or on the amendment? Hearing none, the questions on the amendment, all those in favor signify by saying aye. Those opposed, no. No. Opinion of the chair, the noes have it. Recorded vote's been requested. The clerk will call the roll.
Mr. Burgess?
No.
Mr. Burgess, no. Mr. Reschenthaler? Mr. Reschenthaler, no. Mrs. Fishbach? Mrs. Fishbach, no. Mr. Massey? Mr. Massey, no. Mr. Norman? Mr. Norman, no. Mr. Roy? Mr. Roy, no. Mrs. Houchin? Mrs. Houchin, no. Mr. Langworthy? Mr. Langworthy, no. Mr. McGovern? Ms. Scanlon? Ms. Scanlon, yes. Mr. Neguse? Mr. Neguse, yes. Ms. Ledger Fernandez? Ms. Ledger Fernandez, yes. Mr. Chairman?
No.
Mr. Chairman, no.
The clerk will report the total.
3 yeas, 9 nays.
The amendment's not agreed to. Are there any further amendments for discussion? Hearing none, the question is on the motion to report. All those in favor signify by saying aye. Aye. Those opposed say no. The opinion of the chair, the ayes have it. A recorded vote's been requested. The clerk will call the roll.
Mr. Burgess? Mr. Burgess, aye. Mr. Reschenthaler? Mr. Reschenthaler, aye. Mrs. Fishbach? Mrs. Fishbach, aye. Mr. Massey? Mr. Massey, aye. Mr. Norman? Mr. Norman, aye. Mr. Roy? Mr. Roy, aye. Mrs. Houchin? Mrs. Houchin, aye. Mr. Langworthy? Mr. Langworthy, aye. Mr. McGovern? Ms. Scanlon? Ms. Scanlon, no. Mr. Neguse? Mr. Neguse, no. Ms. Ledger Fernandez? Ms. Ledger Fernandez, no. Mr. Chairman?
Aye.
Mr. Chairman, aye.
Clerk will report the total.
9 yeas, 3 nays.
And the ayes have it. The motion to report is agreed to. Accordingly, Dr. Burgess will be managing the rule for the majority. Representative Ledger Fernandez for the minority. So with that, and without objection, committee's adjourned. Thank you all for your patience and endurance.